StudyIQ IAS. अब तैयारी हुई affordable.
Okay, so we'll proceed with our next topic. So what are the topics that you have covered till this point of time? We have tried to cover the philosophical area, the values and all those things where you can definitely expect one question. Then we covered the fundamental rights, which includes the DPSP, where you can expect fundamental rights, DPSP, fundamental duties, so everything including 2 questions. So 3 questions, and then we have covered the parliament. So parliament you can expect 2 questions also, but minimum 1 question. And then we have seen the executives, then we have seen the judiciary part, so separation of powers. So here you can expect 1 or 2 questions. So 5 to 6 questions is something that you have already covered. So try to definitely take it into your mind, put it into your mind that not only for the subject polity, but for the other subjects also, the biggest problem with the students, especially when you write the mains examination, is not that you are not aware of the content. You can listen to this multiple toppers also, that you read from multiple sources, but when you write in the examination, you will not be able to recollect all the things that you learn from the multiple sources. It's not about that you are not aware of certain things, but it is all about how much you can recollect when you write the examination. And see the successful candidates, it is not only my own experience, but I have also listened this from number of toppers, that they were able to write well in the mains examination just because they have consolidated their note to a single source. And they have tried to revise that particular source multiple times. And you know that you cannot write too much of content, even if you know. So you have to derive the important contents and consolidate that content, revise it multiple times. If you follow that approach, your mains is very, very easy. For many students, clearing prelims is difficult rather than clearing the mains examination. For certain people, that they'll always clear prelims, but it has become a nightmare for them to clear their mains examination. That is because they didn't realize that they have to consolidate their information. And as long as they don't consolidate the information, if the information is not organized, just like the books are organized in the library, you go and you know from where to pick that particular book. And if it is not organized, then you cannot recollect and you will have to write that under a tremendous pressure of 3 hours. So try to organize your information. For each and every subject that you prepare, try to organize the content, try to revise that, and make sure that your content has to be in such a way that you will be able to revise that particular subject maximum in 1 day. It should be even less than that before you go to the examination. So if you have a content like that, so I can remember that I had a content for the optional, leave out the general study subject. I had a content for my entire optional that I could revise my entire optional in 1 single day. That is the kind of crisp notes that I had to revise my entire optional in 1 single day. So that gives a lot of confidence before you go to the examination. And your crisp content need not have all the information. You should have certain keywords, and that keywords will be able to help you to revise and recollect a number of things. All right. So we'll just proceed further. Today we'll move to the next topic, that is federalism. Again, a very, very important topic. Definitely one question will definitely, because in the last 10 years, there was not even a single paper without a question from the topic federalism. So I have identified that what are the major areas that they ask questions. So basically they ask question in 3 areas. So what are the areas where they ask the question? Is 3 areas where they ask the question. So let me give a brief outline as to how I am going to proceed with this particular class. So the idea that I have is I'll try to complete this class somewhere between 2 hours 15 minutes to 2 hours 30 minutes. In one single session, we'll try to complete that. Okay. So that your time is also saved. So what is the structure that we'll have for this particular presentation? We'll try to understand the historical context as to how federalism was there in India and why the Constituent Assembly decided the federalism that we have today. Why they have chosen a federalism which is quasi-federal in nature. What was the idea behind that? Very quickly, so that this will help you to write it as an introduction or a conclusion when you begin an answer for federalism. That's the idea behind this particular analysis. Then we'll quickly move to the constitutional provisions, the important key constitutional provisions which deals with the federalism, because there will be no direct question as to some of the constitutional federal provisions with regard to the kind of legislative relationship, but you can use these articles here and there in your answer so that it can enrich your answer quality. And then issues arising out of constitutional design is very important. So how the constitutional provisions are biased in favor of the union and what are the issues arising out of these things. So this is one area where question has been asked. And then the next area where they have repeatedly asked 2-3 times the question is the emerging trends in federalism in our country. So it is not only about the cooperative federalism, the emerging trends include competitive federalism as well as what is called as the combative federalism. So we will see that with few examples. And there can be certain contemporary issues from where the questions can be exactly asked. Say for example, there's a dispute that is going on between the elected government and the lieutenant governor in Delhi. Case after case it is happening, and then the government is responding by, the government is going to the court and then the parliament is making a law. Recently you have seen that the Delhi government has said that, the Supreme Court has said that the Delhi government has got control over the services. An ordinance was brought in by the parliament. So this is a specific issue related to this. Or there can be a question on interstate river water disputes. Previous year there was a question on CBI. A specific current topic related to federalism can also be asked. So we will also touch upon one or two such things. And then these are the things where you can use it in your conclusion. So I have given certain recommendations which is given by the Sarkaria Commission and the Punchi Commission. I also try to bring in some of the recommendation of National Commission to review the working of the constitution. So use these recommendations in your solutions. And then certain key terms, certain doctrines which has been evolved by the Supreme Court to resolve the disputes between the center and the states. In one year, I remember that there was a question on what is called as harmonious construction and federal supremacy. So the question can also come from these doctrines, or otherwise also you can use it as a part of your answer when you write the answers. So I've tried to bring in certain doctrines, principles and the case laws as well. And then as we'll proceed, we'll also try to look into certain practice questions. So that's the structure that I'm going to have for today's presentation. Okay. So come to the first topic, that is the historical context. Now why we have the kind of federalism and the model that we have. So why we have this particular model? So the idea of federalism can be traced back to the Government of India Act 1919. But although there was no federalism in the Government of India Act 1919, the Government of India Act 1919 provided for only devolution of powers. Can someone tell me what is this devolution of powers? The Government of India Act 1935 provided for what is called as decentralization. So what basically is the difference between devolution and decentralization? So this is basically nothing but a delegation of power. All the powers are centralized only in the central government. The central government was given the power under the constitution. If you see, Government of India Act 1919 was the constitution of India there, for the British India. And similarly, so is the Government of India Act 1935. So in 1919, the constitution, the act is giving power to whom? Only to the central government. And then the central government can delegate certain powers to the provinces. The biggest problem with this is at any point of time, they can take back the power. There is no constitutional protection. But they wanted to have some element of autonomy to the provinces. So they came out to this particular idea of creating responsible government in the provinces as well. This was further improved upon in the Government of India Act 1935. Now in the Government of India Act 1935, they realized that a country with huge size and huge diversity can be effectively administered how? Only through decentralization. And thereby you need to give the provinces the autonomy. But they are concerned about the unity and integrity of India, and they centralize the power. That means although there is decentralization, more powers were given to whom? More powers were given to the center. So this is the idea of the Government of India Act 1935. Now then subsequently, you know what has happened in the history of India. Subsequently, the Constituent Assembly was established, and the Constituent Assembly was established based on the Mountbatten Plan. And when the Constituent Assembly of India was established based on the Mountbatten Plan, you know that was a time that the two-nation theory was also at its peak when the Constituent Assembly was established. And in fact, the Constituent Assembly rejected the idea of two-nation theory, but still the idea was very much live, and they wanted to have a separate state of Pakistan. So one of the ideas by which the cabinet mission thought that they can come out of this two-nation theory is by giving more powers to the provinces. In fact, initially the provinces were to be given more powers and autonomy. But however, you know that later that Pakistan became a separate state, and then there was no much resistance in the Constituent Assembly for making a strong center. Had Pakistan was part of India, the territory of today, the independent state, probably if they remained in today as a part of a single country, probably the kind of constitution we have today may not be there today, because more and more powers would have been given to these states. But as Pakistan became a separate nation, the remaining members of the Congress, they didn't have much resistance to the idea of strong center, because they knew that at the commencement of the constitution, when the Constituent Assembly was drafting, there was a lot of centrifugal forces in the princely states. What do you mean by centrifugal forces? Outward forces who wanted to move away from the core. So that is what is centrifugal forces. So in order to take care of these centrifugal forces and also to make sure that it is going to be a strong center. Dr. B.R. Ambedkar suggested that the federation that will have a strong center, and that is one of the reason they use the expression what is called as union of states. Now, do you know that why they use the expression union of states rather than the expression federation of states, despite the fact that India is a federation? No doubt in that. Because it's not a true federation, and also it also implies that no states in the future will have the right to secede from the union. They will always be part of one single country, that they will always be part of the union. And also it implies if the union wants, the union can unilaterally destroy the states. So those things are implied under the expression union of states. And this is exactly what was told by Dr. B.R. Ambedkar in the Constituent Assembly. And that's why the federation today in our country, we call that federation with a strong center, or we say that it is a federation with unitary bias, or it is a federation with centralizing tendency. Now, this 5 minutes of lecture is to just to use these things somewhere in the introduction or in the conclusion as and when it is required. So, accordingly, you can use this. Alright. So, now we will just get into know the constitutional provisions very quickly. You are aware of the most of the constitutional provisions. Let me just quickly brief you so that you can use these provisions wherever it is relevant. Shall I proceed to the next slide? Done? Alright. So, write down the next thing, that's the constitutional provision as to what is the scheme of division of powers between the center and the state. If you see the scheme of division of powers between the center and the state, so we know that majorly it is divided under 3 headings or under 3 areas. One is the legislative powers, another is the executive and the financial powers. So, what is a major article that is dealing with the division of the legislative powers? So, you can just come to the first thing. So, one of the most important article is Article 245 of the Constitution when it comes to the legislative powers. It talks about application of laws which is made by the Parliament. So, what do you understand by the term application of law made by the Parliament? So, to what extent the law made by the Parliament can apply? So, to which part of the country the law made by the Parliament can apply? So, it says that the law made by the Parliament can apply not only to the entire territory of India, but it can also have extraterritorial applications. But whereas the law made by the state legislature will have strict application only in the territory of the concerned state, not beyond the territory of the concerned state. And then Article 246 gives us the idea as to where these laws can be made. What are the areas on which the laws can be made? And what is the source of the Schedule 7 of the Constitution? It is Article 246 which is the source of Schedule 7 of the Constitution. Article 246 only says that these are all the areas on which the Parliament can make laws, for which you can refer to what is called as the Schedule 7 of the Constitution. And you know it provides for the 3 lists, that is the union list, state list and the concurrent list. The Schedule 7 talks about only these 3 lists, and I hope you understand as to what is the power under these lists. But then there is no residuary list which is given in the Schedule 7 of the Constitution. The residuary powers of the Parliament comes from Article 248 of the Constitution. So, can someone tell me what is this residuary powers? Which is not found in any of these 3 lists, which is within the power of the Parliament to make laws. Now, does it not give a bias that to the more power to the Parliament? In fact, not only the residuary powers, even if you see under Article 246 where the Schedule 7 comes from, more items are there in the union list. And then you can also understand that over a period of time, certain amendments has been made. Say for example, the 42nd Constitutional Amendment Act, which is related to 7th schedule. Can anyone recollect this 42nd Constitutional Amendment Act related to the 7th schedule? Where 5 items has been moved from the state list to the concurrent list. So, this also you will understand that more power is going to whom? To the center. That means movement from the concurrent state list to the concurrent list means you are enhancing the power of the Parliament. So, you can see the amendments which has been happening in that way. You can see the Article 246, Schedule 7 is in fact biased towards the power of the Parliament, and then on top of that you are giving the residuary powers. And then there are also certain other powers which I would say all these things contribute to what is called as federal supremacy. Have you ever heard of this word federal supremacy? So, say for example, the Constitution of India provides for an inherent bias towards federal supremacy comment. So, what do you understand by this federal supremacy? In the scheme of division of powers, the division of power is not equally done, but rather there is a bias in favor of one particular government, or let us assume one particular authority. So, this is basically what is called as federal supremacy. When we talk of federal supremacy, that this scheme of division of powers is in favor of the central government. So, that is basically what is called as a federal supremacy. So, try to use these words when you write the answers. Okay. So, these words are going to give more expression rather than writing more. You just use the word federal supremacy, it is understood that what you are trying to explain. Okay, so try to put in a lot of words that I am going to discuss today in your answer. So what are the examples of the federal supremacy when it comes to the legislative powers? So I'll try to make you understand the federal supremacy with regard to each and every powers. So this is with regard to the legislative powers. So all these articles, if you see Article 249, Article 250, Article 252, Article 253, Article 356, they are all giving more powers to whom? They are all giving more powers to the center. So they are all basically examples of what is called as the federal supremacy. So even if you don't remember what these articles are, try to remember one or two articles. Now what is these articles about? All these articles enables the parliament to make a law on an item in the state list under different circumstances. So for example, Article 249, the Rajya Sabha passes a resolution and they can empower the parliament to make a law. What about Article 250? When there is a national emergency, the parliament can make law. Article 252, when two or more states make a request, the parliament can make law. Article 253, to implement an international treaty, the parliament can make a law. Article 356, when there is a president rule, the parliament can make law. So even if you don't have to explain all those things. So probably you can write, say for example, Article 249, Article 356. Just try to give few examples when you write the answers. Don't keep explaining these things unless and until the question itself is centered around this particular thing. Otherwise, it's just an example for your answer, so that your answer looks more qualitative in terms of the content. And then Article 254 of the Constitution is a classic example of again federal supremacy, because Article 254 of the Constitution says in case of any inconsistency between a parliamentary law and a law made by the state legislature in case of an item in the concurrent list, which law is going to prevail? To the extent of such inconsistency, the parliamentary law is going to prevail. So that means even in case of the concurrent list, although the state legislature are given to make law, but ultimately which law is going to prevail? The law made by the parliament. So that is an example of what is called as the federal supremacy. And then come to Article 3 of the Constitution. So here also there is a federal supremacy in terms of the legislative powers, because under Article 3, the parliament can unilaterally destroy the states. Does the states have any say in the reorganization? You cannot say that as a say, because the opinion which is given by the state legislature is not binding. So as long as it is not binding, then you cannot say that to be a say. Okay. So here also there is what is called as a federal supremacy. So you'll have to understand that everywhere there is a federal supremacy. And then you see Article 200 of the Constitution, the governor can reserve the bills for the consideration of the president. And here it is very important when you say that the governor can reserve the bill for the consideration of the president. In fact, this is what? This is the discretionary power of the governor. So can the governor reserve all the bills for the consideration of the president and create problem to the states? No, which bill he can reserve is his discretionary power. If you want to reserve any bill, he can do that. So the Constitution does not say which bill he has to reserve, only one thing. If any bill is going to affect the powers of the High Court of the concerned state, there it is mandatory for him to reserve the bill. Otherwise, which bill he is going to reserve is his discretionary power. There is nothing that the states can do about it.
Money bill also.
Any bill he can reserve for the consideration of the president, which the governor should not normally exercise looking into the constitutional scheme of things, but that is a constitutional vacuum, or you can say that it was deliberately done in such a way of giving more power to the center, or the center to have control over the states. Okay. So this is again a problem. And then Article 248, which gives the residuary powers to the parliament. So can you see that in all these cases there is a federal supremacy? So federal supremacy is very much inherent in the Constitution. Suppose if a question comes, what are the issues in the federal relationship that is arising out of the constitutional design? Now, so this is a constitutional design, and this design, can it raise an issue between the center and the states? So these are the areas that you have to point out. Article 254, inconsistency between the central law and the state law when it comes to concurrent list. This is an issue that is arising out of the constitutional design. So once you understood that there is an inherent bias, now because of the inherent bias towards the federal supremacy, already a number of issues has come up before the Supreme Court. Because any federal dispute will go to whom? The Supreme Court has got the original jurisdiction with regard to the federal disputes. Can anyone recollect the article which provides the original jurisdiction of the Supreme Court? Very good. Article 131 of the Constitution. So if need, you can use this Article 131 of the Constitution as well. which provides the original jurisdiction to the Supreme Court. The original jurisdiction is given to the Supreme Court of India under Article 131 of the Constitution. So, already a number of federal disputes which were there, please understand. Now, all these federal disputes were addressed by the Supreme Court of India, and the Supreme Court of India has innovated certain doctrines to address these issues. Now, one such important principle is what is called as principle of harmonious construction, because there can always be a dispute under Article 254 of the Constitution. What does Article 254 of the Constitution says? Inconsistency between the parliamentary law and the law made by the state legislature, which is going to prevail. So, the Constitution recognizes a federal supremacy, but at the same time the court recognized the need to protect the interest of the states as well. There is a federal supremacy in the Constitution, but doesn't mean that we will not protect the interest of the states. So, taking into consideration one, the federal supremacy under the Constitution and the need to protect the interest of the state, the Supreme Court of India has innovated this particular doctrine, what is called as the principle of harmonious construction. So, what exactly is this principle of harmonious construction? The principle of harmonious construction says, just listen to me for a moment. What is this principle of harmonious construction? Then you can write it. You listen and then you write it, you will remember for a long period of time. Now, what is this principle of harmonious construction is saying? That if there is a particular law and if there are two contradicting provisions within a particular law, let us assume two sections, they contradict one another. Now, the Supreme Court has to try to interpret them in such a way that they give effect to both the provisions, because the idea is both the provisions were brought in with a particular intention, with a particular objective. As far as possible, you try to resolve the conflict between them and try to give effect to both the provisions. That is one case. Or if there is a conflict between a law made by the parliament and the law made by the state legislature, and there is a conflict between certain provisions of the parliamentary law and certain provisions of the law made by the state legislature, you try to resolve the conflict by different interpretation and try to give effect to both the provisions as far as possible. If it is not possible, then the parliamentary law will prevail. But as far as possible, try to do away with this conflicting interest, or try to give an interpretation in such a way that they do not conflict with one another. So, this is basically what is called as principle of harmonious construction. Because the idea of principle of harmonious construction is that you are recognizing federal supremacy, at the same time you are also trying to protect the interest of the states. If this principle of harmonious construction is not there, then what will always prevail? Always the thing that will prevail is the federal supremacy. So, to protect the interest of the states, the Supreme Court came out with this particular doctrine. In fact, this happened in a case which is called as Kerala Education Bill 1957. In fact, this is not even a case, it was referred to the Supreme Court by the President of India under the advisory jurisdiction of the Supreme Court. So, which article is dealing with the advisory jurisdiction of the Supreme Court? 143. Okay, although not relevant here, but so through that it was referred to the Supreme Court, and through that particular case, the Supreme Court innovated this principle of harmonious construction. Okay, so write down this principle of harmonious construction. Then the next principle that you have to understand, if you have written that, is doctrine of pith and substance. Okay, make a note of this harmonious construction, and then I'll move on to the doctrine of pith and substance. Then the federal supremacy will automatically come into effect, because that is what the Constitution provides for. So next thing is doctrine of pith and substance. So what is this doctrine of pith and substance? Again, let us assume that there can be conflict between the parliament and the state legislature, or there can be conflict between the center and the state, saying that one legislature is trying to encroach the power of the other legislature. One classic example would be the farm laws. The farm law has been repealed by the parliament today, but do you know that the farm laws, 3 laws which is related to the agricultural reforms, are the farm laws, which is basically called. Now, all these laws were challenged by various state governments. Can you recollect some of the state governments which have challenged these farm laws? West Bengal is one such state. Punjab was there, Kerala was there. Now, all these governments were party to this particular farm law, which was challenged in the Supreme Court under Article 131 of the Constitution. Do you know what is the major contention as to why these farm laws were challenged? Why the states have challenged these laws? Because they said that agriculture is an item in the state list. It is mentioned number of times in the state list, but there is one area where it is also mentioned in the concurrent list, which is dealing with agricultural manufacture, produce and sale of certain agricultural items. And in that agricultural items also, only the oil, seeds and all those things are mentioned, but not much about the agriculture is mentioned. So, the basic contention of the state is that the parliament is trying to encroach the power of whom? Power of the state legislature under the constitution, which in the opinion of the state is unconstitutional because it is within their legislative competence, where the parliament does not have the power to do that. If at all the parliament can do that, they can do that under article 249 or article 250, article 253 or article 356, but nothing of that sort has happened when the parliament has made the law. So, the state says that it is a clear violation of their powers which is guaranteed under the constitution. And similarly, it might be possible that the states are also trying to make a law on an item in the union list. So, nothing can prevent the parliament and the state legislature from doing this, but ultimately that can be declared to be unconstitutional and void by the courts if the matter is brought before the court, because the federal dispute falls under the original jurisdiction of the Supreme Court. To resolve such dispute, the Supreme Court has already innovated a doctrine which is called as doctrine of pith and substance. It's not a new doctrine which the Supreme Court has brought in. It's a very old doctrine which the Supreme Court has innovated way back in 1951 itself in a case which is called as State of Bombay versus F and Balsara case. But subsequently, it has applied this principle in number of other cases as well. So, you'll have to basically understand as to what is this doctrine of pith and substance. The doctrine of pith and substance says that when there is a matter before the court where the petition is brought in by one legislature or the other, but then the allegation is that the other legislature is trying to encroach the power of the states, or say for example, the state legislatures are making an allegation that the parliament is trying to encroach their power, or it can be vice versa also, that the parliament is making an allegation, the central government is making an allegation that the state legislature is taking up their power. In all these cases, what the Supreme Court has to do, the Supreme Court has to look into the very essence on which the law has been made. Say for example, every law which is made either by the parliament or by the state legislature on a particular subject matter. So, what should be the idea of the Supreme Court, or what should be the role of the Supreme Court? The role of the Supreme Court in this particular case is to look into the very essence or the subject matter or the core of the subject matter on which the law has been made. If the core of the subject matter or the very essence on which the law has been made is related to an item in one list, it doesn't matter even if there is an incidental encroachment upon an item in the other list. So, here the intention of the parliament, suppose let us assume that the parliament is making a law, and it is making a law, if they are able to prove it in a court of law that I am making a law on, say for example, that the parliament has made a law on what is called as the national security. National security is an item in which list? It is there in union list. Protecting the sovereignty, integrity and the national security, everything is there in the union list. Suppose let us assume that the parliament is making a law on this particular item, the national security or the sovereignty and integrity of India. But suppose let us assume that some of the states are challenging this particular law on the ground that it is having an impact on the law and order or the police or the public order, which is an item in which list? State list. So, will it lead to a conflict? Suppose let us assume that to protect the national security, the central government is creating some force, let us assume, and they are giving these force certain powers of investigation, which in the opinion of the state, it is directly having an impact on the public order and the police, which is mentioned in the state list. Now, can such a law lead to dispute between the center and the states? Now, what is the idea behind this doctrine of pith and substance? So, in such cases, if the dispute arises because of this particular reason, then the Supreme Court said that we will apply what is called as the doctrine of pith and substance. In doctrine of pith and substance, we will try to understand as to what is the core essence on which the law is made. Is the law is made on law and order, or is the law is made on national security? If we come to a conclusion that the idea behind this law is to protect the national security, the idea behind this law is to protect the sovereignty and integrity of India, but there is an unintentional encroachment. But because of this law, there is an unintentional, that is what is called as an unintentional encroachment or an incidental encroachment upon a power upon the state list as well, upon the states as well. Still, that law would be considered to be what is called as a valid law. But if you see that it is not an unintentional encroachment, it is an intentional encroachment. Whatever law that you have made is not on your subject matter. You have deliberately made a law on another subject matter, but you are giving a color to that particular law as if you are making a law in your own item. Then that would become what is called as a colorable legislation. So, these are two doctrines which has been innovated by the Supreme Court to see whether a law that is made by a particular legislature is valid or not. In fact, if the farm laws were to be proceeded by the Supreme Court, probably the law might have been struck down as what is called as a colorable legislation, because it was very clear that there was no competence for the parliament to do that. And the pith or the core items on which a law is made is not within their legislature, but it is where? It is there in the state list. But I think the parliament recognizes this, the central government recognizes, probably they repeal their own laws. So, two examples which has happened in the recent past, one is the farm laws and other is the NI Act 2008. So, you can just copy down this doctrine of pith and substance and colorable legislation, and then I will just explain what is the position of this NI Act. Farm laws anyways we know that it has been repealed. So, this is also an issue as an example that you can use where these doctrines have come across in the recent past. Is it clear as to what is this doctrine of pith and substance? Doctrine of colorable legislation? Is it clear? Under the doctrine of colorable legislation, it is saying what you cannot do directly, you cannot do indirectly also. That is not possible. It is not your power to do that. So, if it is a colorable legislation, it is very clear that the court will strike it down. Under the doctrine of pith and substance, if you are making a law in your own area, but if there is an unintentional encroachment upon the powers of the state, still the law can be considered to be what is called as a valid law. Do you know this NI Act is right now presently sub judice in the court of law? Now, what is the reason as to why this NI law is challenged? Do you know what is this National Investigation Authority, National Investigation Agency? When it was created in 2008 and in response to what? The Mumbai terror attack, and they realized that there is no centralized agency to deal with terror related cases. And subsequently, the NI Act was passed and this NIA agency was created, National Investigation Agency was created. Now, this the NIA Act has empowered this National Investigation Agency to carry out terror related investigation not only within the central government, but it can carry out such investigation throughout the territory of India, anywhere that happens in the territory of India. And they do not have to take the permission of the concerned state before starting an investigation, suppose if the terror attack has happened in any of the state. Now, many states had a problem with this particular law, that it has an impact on what? The law and order, which is an item in the state list. Public order is an item in the state list. And to that extent, this particular law was challenged, and it is even now pending in the Supreme Court. So, if you apply the doctrine of pith and substance and the doctrine of colorable legislation, how many of you think that it may be considered to be a colorable legislation? Is it a colorable legislation, or under the doctrine of pith and substance, this law may be considered to be valid law? Although the law is still sub judice, but most likely the law would be considered to be a valid law. Because the intention here is not to encroach upon the law and order or the police powers of the state. The intention is to provide to preserve the unity and integrity of this nation, is to act upon the terrorist, where the state police and coordinating with the state police has become very difficult for the central agency. So, the idea is that they have made a law. This is what the petition made by the center has also said. Our idea is not to encroach upon the powers of the state. The idea is only to protect the sovereignty and integrity of India, is to preserve the security of our country. And hence, we have empowered a central authority, but there may be an incidental encroachment, but that is not the intention. It is an unintentional encroachment upon the powers of the state. Okay. But however, the farm laws would have been a colorable legislation. But although this has been repealed, but this matter is sub judice. So, you can use these as examples as to how these doctrines were to be applied by the courts, okay, when it comes to these principles. So, shall I proceed further? In the recent past, at least in the last 10 years, nothing. We have very old legislation like in the FN Balsara case and all those things, because it does not happen often. So, in the recent past, only these two examples I could find in the last 1 decade. Okay. So, it is better that you use these examples itself. Write down the next thing, that is the executive relationship. So, the executive relationship between the center and the state is surrounded under what is called as Article 256 of the Constitution. It is Article 256 of the Constitution that talks about the executive relationship. If you see Article 256 of the Constitution, does anyone know what is this Article 256 of the Constitution says? What is the crux of Article 256? Very, very important. That defines the executive relation between the center and the states. In fact, this Article 256 you will understand, it is very, very important that you understand under Article 256 that the executive power of the union, please understand, the executive power of the states, rather I would say what is the executive power of the states? The executive power of the states extends in those areas on which the parliament can make laws, or the executive power of the state has to be carried out in compliance with the law made by the state legislature. Is it true? That means the executives cannot function in a way which is contrary to the law made by the state legislature. So, their executive power has to be in consonance with the law made by the state legislature. This is one aspect of it. But Article 256 also says that the executive power of the state should also be in consonance with the law made by the parliament. That means your executive power cannot be carried out contrary to the law made by the parliament, and your executive power shall not be carried out contrary to the law made by the state legislature. But that is not the case with the union executive. For the union executive shall not carry out their executive powers contrary to the law only made by the parliament. But whereas the executive power of the state is constrained by both law made by the parliament as well as the law made by the state legislature. That means again, who is having more executive powers? Union. And also one more thing that you have to understand in Article 256, if there is any deviation in terms of the executive powers of the union with regard to the law made by the parliament, then the union government can give directions to the state executive. The union executive can give directions to the state executive under Article 256 that you are deviating, so don't deviate and carry out this. Now, one example that I can bring here is that there was something which is called as Citizenship Amendment Act 2019. Now, this Citizenship Amendment Act 2019 is sub judice. It is challenged in the court of law. But the court has not put a stay on this execution of the Citizenship Amendment Act 2019. That means basically till the time the Citizenship Amendment Act merit will be decided, the government can keep implementing the Citizenship Amendment Act 2019. There are a lot of controversies beyond doubt, but the law has not been stayed. Now, do you know some of the state governments like West Bengal, Kerala, they openly said that we will not implement the Citizenship Amendment Act 2019. Have you come across this particular news? Yes. That they openly said that we will not cooperate and we will not implement this particular law. Now, is it constitutional for the states to come and say that they will not implement a central law? It would be a clear violation of Article 256 of the Constitution. What does Article 256 of the Constitution says? Article 256 of the Constitution says that the executive power of the states, I am just repeating it, please listen to this. The executive power of the state shall be in consonance with the law made by the state legislature, and it is not only in consonance with the law made by the state legislature, but it should also be in consonance with the law made by the parliament. If they are not showing consonance, or if they are not showing, or if they are not behaving in such a way which is showing consonance with the law made by the parliament, then the union executive can give direction to the state that you are deviating from this law, you ensure compliance with this particular law. This is what Article 256 is saying. Article 256, the union can give directions to the state executive, or the union executive can give direction to the state executive under Article 256. Now comes the important point. Okay, let us assume under Article 256, the union is giving the direction. It is giving direction to whom? Giving direction to the states. So, suppose let us assume that the West Bengal and Kerala are not implementing the Citizenship Act 2019, Amendment Act 2019. Can the union government send advisory? Can they give directions to the state government? Okay, let us assume under Article 256, the advisory is sent to these two governments. And despite that, let us assume that there is non-compliance. So, then we will have to understand as to what will be the consequence of this non-compliance. And you will see the consequence of this non-compliance is there in Article 365 of the Constitution. And what is this Article 365 is saying? Article 365 is saying effect of failure to comply with the directions given by the center. That means under Article 256 they can direct, and Article 365 is talking about the consequence. And what is Article 365 is saying? That if any direction is given by the center, which is a constitutional direction, of course the center cannot give any direction. A center cannot direct the state to do something which the law does not say. That is not possible. So, suppose any constitutional direction is given by the center to the states, and if the state is not implementing that, then what is the consequence which is provided in Article 365? Article 365 is saying that the president can come to a conclusion that there is a constitutional breakdown in that particular state. That means basically the president can come to a conclusion that the administration of the state is not carried out in accordance with the provisions of the Constitution. Because in accordance with the provisions of the Constitution, there is a need to ensure compliance. And if there is no compliance, what is the consequence? That the center come to a conclusion that your administration is not carried out in accordance with the provisions of the Constitution, and there is a constitutional breakdown. And if there is a constitutional breakdown, then what is the further consequence? Then the president can invoke Article 356 of the Constitution. So, Article 365 is not a ground to impose a president rule. Article 365 is only a provision where the president can come to a conclusion that there is a constitutional breakdown. I think in your Lakshmikant book, I think it is given that under 2 articles a president rule can be imposed. No, there is only one article which gives the power to impose a president rule. What is the article? Article 356. In fact, if you see the emergency part talks about only Article 350 to Article 360. It is not talking nothing more than that. So, to say that the president rule can be imposed under Article 365 is a wrong thing. It is only Article 365 talks about as a consequence of the constitutional breakdown, the president can invoke Article 356 of the Constitution. So, try to understand. So, then it can lead to what is called as the president rule. Now, from these provisions, is there a federal supremacy with regard to the executive powers? So, how do you derive the federal supremacy in all these things? So, please understand Article 256. Article 256, who can direct whom? Only the union can direct the state. Can the state direct the center? That's not possible. And who can come to a conclusion that there is a constitutional breakdown when there is a non-compliance? The center. So, please understand Article 256, Article 365, Article 356, there is an inherent bias in terms of whom? Inherent bias to the center. And that is again an example of what is called as the federal supremacy. But again, you understand that here you can incorporate the SR Bommai case and all those things. That the SR Bommai case has become a benchmark to prevent the misuse of these powers. Because in the SR Bommai case, the Supreme Court has given certain guidelines under what circumstances the president rule can be imposed. What can be seen as a constitutional breakdown. In fact, the SR Bommai has cases explained. So, here you can see the doctrines that I used earlier, which is specifically related to the legislative relationship. So, here you can incorporate the SR Bommai case, where the Supreme Court has tried to balance between the federal supremacy and the misuse of such powers by the center against the state. Okay, does anyone know what can be seen as constitutional breakdown? Because in the SR Bommai case, the Supreme Court categorically said as to what is the difference between administrative breakdown and constitutional breakdown. So, can you differentiate between this administrative breakdown and the constitutional breakdown? Law and order is a constitutional breakdown. It is a responsibility of the state to maintain the law and order. Suppose let us assume in a particular state there is no law and order, and then the people cannot live peacefully. So, if they are not able to protect the law and order, then there is a constitutional breakdown which the court has categorically said. It is not only about the losing of majority. In fact, in 1999, president rule was imposed in the state of Bihar for large scale I think protest, and I think there is a lot of violences that happened throughout the state of Bihar. And then the president rule was imposed. Later it was revoked for certain reason, that is a different thing. But law and order is seen as a constitutional breakdown. What is administrative breakdown? Say for example, charges of corruption against a minister, charges of corruption against a chief minister. That is not a constitutional breakdown. Or let us assume that the center is feeling that the state government is not ensuring the welfare of the people, their welfare policies are not good. That is an administrative breakdown. That is not a constitutional breakdown, because when there is an administrative breakdown, when the welfare policies are not good, it is not for the center to come to a judgment as to the policies are not good. Who are to judge that? The people of that particular state, they have to vote this particular government out of power. So, you should not be worried about all those things. Your duty is only to impose a president rule when there is a constitutional breakdown. If you lose majority, constitutional breakdown. Elections are over, nobody is able to form the government, then there is a hung legislature, that is a constitutional breakdown. Or you have a majority but still you are not able to maintain the law and order, that is a constitutional breakdown. So, very, very important. So, on the one hand, federal supremacy, and to prevent the misuse of federal supremacy, you can quote the SR Bommai case. And then now come to the contemporary issues with regard to the executive relationship. Amendment to the All India Service Cadre Rules. So, this is one of the recent dispute between the center and the states. Can anyone recollect as to what this particular dispute is? The dispute between the center and the states. What has happened? That is true, that is the case. Now, there is an All India Services Act. Under the All India Services Act, the rules can be formulated by the central government. These rules are basically what is called as delegated legislations. Now, if you look into the All India Services rules today, now first of all, why do you consider these rules to be services to be All India services? These are the services where both the center and the state have some element of control over these offices. In the central services, who will have the control over these officers completely? The central government. But all India services are those services where the center recruits them through the Union Public Service Commission. But these officers are going to serve the states. And the states do have some element of control, not much control, but some element of control with regard to the transfers within the states, with regard to suspension, some disciplinary activities, not much, but the ultimate control lies with whom? Only with the center. But the states also do exercise. So, what are the all India services in our country right now? IFS means forest service or foreign service? It is not foreign service, it is forest service. Foreign service is a central service. So, these are the services, all India services. So, under the All India Services Act, the rules can be made by the central government, but now they have unilaterally changed these rules. Earlier, the rules was that you know that the All India Service officers can also go for deputation. Today, you see that number of secretaries in the government of India who are sitting in the North Block and the South Block, these officers belong to a particular cadre actually. They are already assigned to a particular cadre, now they are on deputation to the center. And during their course, during their tenure, they can go for deputation for a certain number of years, 5 years or something, they can go for deputation. So, what happens is normally when they are about to retire, they come on deputation to the center. Because there are no separate officers at the center recruit for IAS, it is only for the center and the states. Now, what has happened is, under the All India Services rules earlier, that if any officer from a state, if the center needs a particular officer for his expertise or something, then the center will intimate the state to relieve this particular officer. Then the state will relieve this officer, then he will come and join the deputation in the center. But what has happened is earlier the state have to relieve him. But what has happened over a period of time is many states, because of the center state issues between them, they failed to relieve these officers. Despite repeated reminders which is sent by the union government, for some reason, for genuine reason also, we may not know because he may be involved in some work in the states as well. The states has not relieved these officers on time and it has created problem to the center. And under the earlier rules, first it has to be intimated to the state and the state has to relieve these officers, then only he can go for deputation. But now the new rule says, which has been amended by the center, the new rule says without even the permission of the state, they can relieve these officers and they can take the officers to the central deputation. That means now the consent of the state is not required for taking any officer on deputation to the center. So, that is exactly has created some kind of tension between the center and the states. So, now this is also an example of what is called as, is an example of cooperative federalism or this is an example of confrontational approach between the center and the state. Confrontational. The center should be even more mature to handle this particular issue, even if this issue was happening for some time. So, without the consent of the states, if you can call back any officers, then it is also affecting the states and it is creating a conflict, it is creating a mistrust between the center and the state. Okay. So, that is one problem that has happened in the recent. In fact, it has happened with the state of West Bengal, Kerala and some of the other states also. And then one more example is the extension of the BSF jurisdiction up to 50 kilometers. So, you might know that BSF is what? Border Security Force. Now, BSF is not a police, it is just a central armed police force. It is part of the central armed police force. And BSF jurisdiction is, do you know between which country and which country? India and Pakistan and India and Bangladesh. So, in the border areas, they are posted, the BSF. And because of the infiltration and because of the smuggling and all those things, BSF was posted in the border and they have also been given jurisdiction beyond the borders also, up to 50 kilometers. Earlier, now that has been extended to, so initially I think it was 15 kilometers or something, now it has been extended up to 50 kilometers. Which means that up to 50 kilometers, the police doesn't have the power from the border. Who is having the power? The BSF. So, the state governments of West Bengal, which is because of the border with the Bangladesh, Punjab because of the border with Pakistan. So, they are not happy with this. They feel that it is an encroachment upon the powers of the state. Okay, so here this dispute has also come in the recent past. And then you know that the withdrawal of general consent of the CBI by various states. In fact, 7 to 8, 9 states have withdrawn the general consent which is given to the CBI. So, how many of you are not aware of this general consent by CBI? Anyone who is not aware of this general consent clause? It's okay if you are not aware of that. I will briefly explain about that. Now, if you see that CBI today in our country, the CBI, it's a constitutional body or a statutory body? It is neither a constitutional body nor a statutory body. It's a body which is established by an executive resolution. I just want to know how many of you are aware of this. CBI is not established by law. CBI is not established under the constitution. CBI is just established by an executive order. But the CBI continues to derive its power from the Delhi Special Police Establishment Act. See, creating a body by law is something, but creating a body by executive action, but this body will continue to derive a power from a particular law. So that is what is the case with regard to CBI. That means tomorrow if the CBI is to be abolished as a force, it does not require a law. The executives can just abolish this. But as long as CBI is there, the CBI will derive the power from where? Delhi Special Police Establishment Act. And there is this Delhi Special Police Establishment Act. Initially there was something which is called as Delhi Special Police. There is a history behind the CBI, I am not getting into that. Initially there was a Delhi Special Police, and this Delhi Special Police was established mainly to look into the corruptions that happens in the central government. Initially with regard to the war department that happened during the Second World War, and then later on they extend this Delhi Special Police jurisdiction to all the central government departments, especially to look into the corruption. And it was this Delhi Special Police which has given the power. And then gradually they thought that we need a particular body which will not only look into corruption but also severe criminal offences in our country, international crimes that is affecting India, serious economic offences which is affecting India. For all these things they needed a better force, and then they created what is called as CBI. So all those things, that is what the international crimes which is affecting India. So it was basically done on the recommendation of Santanam Committee, and subsequently CBI was created. Initially when CBI was created by an executive order, it was under the Ministry of which ministry? Ministry of Home Affairs, but today it is under the Ministry of Personnel and Training. But still CBI continues to derive its power from the Delhi Special Police Establishment Act. So if you see the Delhi Special Police Establishment Act, that gives CBI, today CBI is the premier investigating agency of the central government. Or I could say that similar to that of the state police in all the states, now CBI is the police for the central government. CBI have a number of police forces or other analogous forces. Who is the premier investigating agency? It is a CBI. And the CBI derives its power from whom? It derives its power from the Delhi Special Police Establishment Act 1946. If you look into this Delhi Special Police Establishment Act, there is a section which is called as, in fact, if you look into the provisions of the Delhi Special Police Establishment Act, the Delhi Special Police Establishment Act gives a power to the CBI only to investigate in the National Capital Territory, Delhi region. So whatever related to offences or the corruption that happens, here it has the power. It can investigate outside this particular region of National Capital Territory of Delhi, but to make any investigation outside this particular territory, they have to take the consent of the states. If the states gives the consent, then they can do that. So that is what exactly section 6 of Delhi Special Police Establishment tells. And that is basically what is called as general consent. So that means you take the consent. Suppose an incident happens in Maharashtra, any corruption related to incident, then the CBI wanted to investigate this particular case. Can they do that? They can do that with the permission of the state government of Maharashtra. But however, over a period of time, what has happened that on every case to take the consent, it becomes a time wasting process, time consuming process. So, an understanding, a convention has been developed over a period of time under the law itself that every 6 months a general consent will be given by the states. A general consent which is given by the state for the next 6 months, whatever cases in that particular state, they don't have to take a separate consent. And after 6 months time, again the general consent is extended by another 6 months. This is how it continued till this point of time. But recently you can see that how this misuse of CBI in the way that the states are making allegation against the center, that CBI is misused usually for the political reasons. And number of politicians, especially from the opposition party, CBI started investigating on number of charges. One is CBI and other is Enforcement Directorate also. So as a response to this particular action of the center, now many states have started withdrawing the general consent. They said that we will not give you consent in general, but on case-to-case basis, we will give you the consent. For every case, you apply the consent from us, and then on a case-to-case, we will give the consent. So this means that this also has an impact on the genuine cases as well, which can affect the progress of the genuine cases, especially high corruption cases, which can have an impact on the economy. All these things can also get affected. But again, this is an example of what? Confrontation between the center and the states. Okay. So try to have 2-3 examples sufficient in case if there is a question. Shall I proceed further? So come to the next thing, that is the financial relation between the center and the states. financial relation between the center and the state. So, the constitution also provides for an element of fiscal federalism, the way that the finances are to be distributed between the center and the state. And who controls this wheel of fiscal federalism in our country? The Finance Commission. The Finance Commission occupies the driver's seat of this particular fiscal federalism as to how it happens in our country. But anyways, Finance Commission I will discuss tomorrow, because in the next class we will take up the topic of, not tomorrow, day after tomorrow, when we take up the topic of constitutional, statutory, regulatory bodies. I will discuss about the Finance Commission, but let me just give an idea of what is the financial relationship. So, the constitution provides for the distribution of revenue between the center and the state. Because the members of the Constituent Assembly were very much aware that more financial resources are given to whom? To the center under the constitution. There is again a federal bias here, or a federal supremacy, because they can collect items, finances on all the items in the union list, whereas the states can collect items only in the state list. So, too many items are given to whom? To the center, and the quantum of items, it is not only the number of items, but the quantum of finances are also more, which is there in the union list. But then the duties of the state are very, very high, because please understand, the duty of the state is not only to implement the state law, but it should also implement the parliamentary law, and hence they also need finances, but then the finances that they can mobilize is very less. So, in order to rectify this particular problem, the constitution says that whatever the resources, the finances through both taxes and non-tax resources that the states can mobilize, they can keep it for their own purpose. But whatever the resources that the center has mobilized, the center cannot keep it all for themselves. Certain amount of revenue has to be vertically distributed to whom? To these states. And who will determine as to how much amount has to be distributed? The Finance Commission. So, tomorrow I will discuss about the day after tomorrow I will discuss about the Finance Commission. But in the recent past, there were certain issues with regard to the financial relation between the center and the states. So, in terms of financial relation also, there is a federal supremacy. But then who is balancing the federal supremacy and the interest of the states? The Finance Commission of India under Article 280 of the Constitution. Okay. So, the balancing wheel is basically done by the Finance Commission under Article 280. So, what are the recent issues when it comes to the financial relations between the center and the state? One is the GST compensation fund. So, is anyone aware of what is the issue surrounding the GST compensation fund? When the GST was brought in? 2017 the GST was brought in, and even if you don't know what is GST and all those things, that is not the requirement under the polity paper. What is the requirement under the polity paper is that how it affects the taxation between the center and the states. Because earlier a number of indirect taxes were under the control of whom? Under the control of the states, which was exclusively domain of the states. Now, all those indirect taxes has been subsumed under one head, which is called as the GST, Goods and Services Tax. Now, the states were not happy for this particular GST reform, but the center has given them a projection that if you go for this major indirect tax reform, that over a period of time, the tax collection will increase, and not only for the center, but also for the states. But then the states had a reservation that initially we may have a loss. Then the center said, don't worry about that. Suppose let us assume that today you are making 100 rupees. In 2017, let us assume that you have collected 100 rupees in the form of the indirect taxes, that whatever you can do. Your concern is that you are feeling that, that the tax money will reduce. But in 2017, if you are making 100 rupees as indirect taxes, 2018 what we will do? You will definitely make more than this 100 rupees. But if you are not making more than this 100 rupees, we will minimum give you a guarantee of 14% increase in this 100 rupee. Suppose if you are not making 114 rupees, we will compensate for the gap. So, minimum how much they said? In 2014, we will get 14%. That is 114 rupees. Whatever is the gap, who is to fill that particular gap? The center will compensate these states. And then in 2018, it will be 14% more of 114 rupees. Whatever is the gap, we will compensate that. So, in this way, we will make a compensation till 2022. So, this is a guarantee that was given by the center in order to ensure the states from having any revenue loss. So, 14% year on year increase that we will guarantee you that for the first 5 years, and after that we are very sure automatically the GST system will pick up and we will start making more revenue. And In 2017, just 1 minute, in 2017 and 2018, most of the states were doing well, and whatever is a shortfall, the center has also given the compensation. Because the center is also a big gainer from these indirect taxes, because 50% will go to whom? To the center from all the states, 50% to the concerned states. And here one of the biggest problem with regard to the GST is the tax will be done in a consumer state, not in the production state. So all these issues were there with the states, and that's why the center said that we will provide you the compensation, do not worry about that. In 17-18 they have given the compensation, but unfortunately 19-20, 21 they are not able to do that because of the COVID and all those things. 18-19 they have done, 20 is the problem that they faced, and then they delayed the GST compensation. And then lot of issues happened between the center and the states, and then the center said, okay, you borrow outside, we will give you the guarantee. And this issue has happened between the center and the states. So it is very much true that the center was not having the fund, but then the way that the center has acted seemed to be little confrontational approach. The center could have arranged the money as a guarantor. They could have borrowed, and as a guarantor they could have provided the fund to the states, because the states are not having much financial resources as that of the center. So it has created a conflict between the center and the states with regard to the GST compensation fund. So this is one issue that happened in the recent past, before 2-3 years, with regard to their financial relationship. And then the next thing is the terms and reference to the Finance Commission. Now this is again a biggest concern, because see, who is setting the terms and references to the Finance Commission? It is a Finance Commission who has to do that, but unilaterally the terms and references are set by whom? By the center themselves. And within the terms and references, the center, the Finance Commission has to work out and share the revenue between the center and the states. Now states are saying that they should also be in party in setting the terms and references. Does it make sense for the states to say that? But today the terms and references are set unilaterally by the center. That is one of the biggest issue. And if you see the terms and references, what specifically happened in the 15th Finance Commission? In the 15th Finance Commission, that the 2011 population was taken into account, and it has been given a greater weightage. But before that, do you know which population census was taken into account? 1971 and not 2011. 2011 was there, but given a very minimal weightage. It is 1971 census which was given the more weightage. Now, if 2011 census is given the weightage, does it have an impact on certain states? Especially the southern states who have reduced their population, and they have reduced the population on the direction which is given by the center. But now you are saying that one of the terms and references, you are saying that more is the population will give you more fund, less is the population will have less fund. Now, the state governments of some of the southern states that we have already invested a lot of money in reducing the population. And now you are saying because you have reduced the population, you will give less fund to us, then that means we cannot accept that. So this is not agreeable. But the center said, don't worry, there is something which is called as performance-based indicators or demographic dividend-based indicators. So if your population is less, on that criteria will give you more fund. If you are better doing in certain areas like education, health indicators, we will give you more fund. So we are going to actually compensate. But this has become an issue actually, this 2011 census which was part of the terms and references. That has become, especially the 4 southern states, they have written to the president and there was a lot of issues that was happening. So that is one issue with regard to the center-state relationship, financial relationship. Reduction in divisible pool of revenue. This is again very, very important, for which you will have to understand that, do you know that the 14th Finance Commission has given a big jump in the share of division of revenue between the center and the states. So before the 14th Finance Commission, it was just 32%, which was consistently used for a long period of time. But what has happened in the 14th Finance Commission, it has given a big boost. The 14th Finance Commission has given 42%. And what is the recommendation which is given by the 15th Finance Commission? And it does not change much, 41%, because they said that one state has anyways reduced. That 1% will be used to the newly created Union Territory of Jammu and Kashmir for the development of Jammu and Kashmir. So otherwise, you are going to have what is called as the 41%. Now, on the one hand, you are saying that we are going to increase the fund. We are going to give the increase, but do you know that whatever is the revenue that is generated by the center is not going to share all the revenues. Suppose let us assume this is what is the revenue that is collected by the center. This revenue is further divided into what is called as the divisible and non-divisible pool. So what will be divided to the states? Only the divisible pool, not the non-divisible pool. That means more the revenue that you collect in the divisible pool, suppose if the percentage is more revenue will go to them. But on the one hand, you are increasing the share of revenue, but you are decreasing the quantum of revenue that is collected in the divisible pool. But what the center is doing now today, they have increased this overall percentage, but simultaneously they have also decreased the quantum of revenue that they are collecting in the divisible pool. And they are increasing the quantum of revenue that they are collecting in the non-divisible pool. That means what the center has started as its policy is today that they are collecting a number of tax through cess and surcharge. Whereas cess and surcharge, which is collected by the center, will go to the non-divisible pool. So more and more cess that they impose on the education cess today, the Swachh Bharat cess today, the fuel cess today. Now all these cess and surcharge, which is collected by the central government, which will go to which area? Non-divisible pool. On the one hand, they are reducing the income tax, but simultaneously they are also increasing the cess. So the divisible pool is getting reduced, non-divisible pool is getting increased. So that is not an advantage to the states. The states are saying that there is no benefit out of increasing this particular share, because ultimately earlier you are giving 32%, but at that point of time it was 200 rupees, let us assume. But now you are saying here it is only 100 rupees, but we will give you 42 out of that. So ultimately they are shrinking what? They are shrinking the divisible pool, because they are collecting more and more finances through cess and surcharge. So that is one of the biggest problem that they have brought in, because cess and surcharge is part of the non-divisible pool. What is the difference between cess and surcharge? Surcharge is also tax on tax, cess is also tax on tax, but cess is for a specific purpose. It can be used only, the money that is collected, the revenue collected can be used only for specific purpose. Surcharge is a general revenue to the government, where the government can use it for any purpose. And then discretionary grant under Article 282 of the Constitution. Do you know that the Finance Commission can also recommend giving certain granting aids? But today you see that number of grants that is given by the center, especially to various states, is done on a very partisan lines. Rather than giving it to the, especially to the development of the backward regions, for the development of scheduled caste and scheduled tribe, the grants can be given by the center apart from this 42% revenue. So in this 42% or in the 41% share, this 41% share that I am talking about is only the vertical distribution. And further, there will also be horizontal distribution between various states. In addition to this fund, there can be certain granting aids can also be given by the center to the states. Today, the biggest allegation is this is done on political lines. Rather than doing that to the necessary states, the backward areas, you are doing that on political lines. Suppose BJP is there in power in the center, the BJP ruled states are benefiting out of these grants rather than giving it to the deserving states. Okay, that is the biggest issue. Increase in centrally sponsored schemes. The states say that the centrally sponsored schemes has already outlived its utility. There is no need for centrally sponsored schemes. So, for example, the budget money that is given, see the share that is given to the states, a certain amount of revenue has to be used to the centrally sponsored schemes. It cannot be used for the other purpose. So, for example, the Kerala government is saying that why should I spend on health and education? Your centrally sponsored scheme is telling me to spend on health and education, but my health and education is far better than already your centrally sponsored scheme. So, I will use it on certain other areas which is relevant for me, and you are not giving me this particular liberty because I have to spend that money on the centrally sponsored scheme, which is not of great use to me. So, this is again a big concern. So, in the 15th Finance Commission, I will tell that already the 15th Finance Commission has recommended an external agency should be appointed to look into whether this should be continued or not, or we have to do this particular system of centrally sponsored scheme. I will discuss more on that when I take up the 15th Finance Commission. Okay, so these are all the issues with regard to the financial relationship. Just try to have few examples with regard to the financial relationships. So now what we have understood the constitutional scheme with regard to legislature, with regard to executive and the financial. In all the areas, we also try to understand as to how there is a federal supremacy. Is there a federal supremacy inherent? And how this federal supremacy is also balanced with the interest of the states. So, for the legislative relationship, we have seen few doctrines which are innovated by the Supreme Court. For the executive relationship, we have seen the SR Bommai case, how the judiciary has tried to balance that. So, here who is the balancing wheel of the fiscal federalism? Here it is a finance commission. It is a finance commission here. Okay. Okay. So because not much of the financial dispute goes to the Supreme Court. It is a finance commission which will deal with. And that is why the finance commission is also called as a quasi-judicial body. Any concerns that the states have, they can bring it to the notice of the finance commission. And the finance commission will try to address these issues. But majorly it is only a recommendatory body, not binding. Okay. So come to this particular question, then I'll move on to the next area. So just have a look into this particular question. So this is a conventional way as to how they can ask question from this particular area. Though the federal principle is dominant in our constitution, and that the principle is one of its basic features. So the federal principle is dominant means that India is basically a federal political system. And federalism has also been declared to be part of the basic structure already by the Supreme Court. But it is equally true that the federalism under the Indian constitution leans in favor of a strong center, a feature that militates means that goes against the concept of strong federalism. What do you mean by strong federalism? A strong federalism means that there is at least equal division of powers between the center and the state, which is also equivalent to that of true federation. On the one hand, we are saying that the federalism is the basic structure of the constitution. But then again, if you see the provisions inside the constitution that leans in favor of the strong center, or it leads to what is called as a federation with centralizing tendency. That is what the question is saying. So, you will have to just explain more on this particular thing as to why there is federalism, why the Constituent Assembly has decided for federalism, but however, why this federalism is a federation with centralizing tendency and what are the provisions in the constitution. And then probably in your concluding remarks, you can also say that why such a federalism has been chosen by the Constituent Assembly. It is not that they are not aware of the fact that the center is given more powers, but they have deliberately given more powers to the center, considering the circumstances at that point of time. So, here you cannot keep explaining more about the legislative powers just because you know more about the legislative powers. You will have to equally write say a couple of points in every cases, in your both legislative, in all the three things, legislative, executive, financial. You can start the conventional way of starting. A safe way of starting is you can define what is federalism or whatever you want to write about federalism in the first 2-3 lines, and then you can say that how there is federalism, but the federalism leans in favor of strong center, although which has been recognized by the basic structure of the constitution. Give examples for that, constitutional provisions, examples for that. But you can also add a line that this kind of federalism has also resulted some kind of problem between the center and the states. And in your concluding remarks, you can make, although the time in which they have decided this form of federalism is to basically preserve the unity and integrity, but in the present circumstances, it is also very important that the strong center should also be supplemented with a kind of cooperative and competitive federalism, so that the interest of the center and the states can be protected. So, in this way, you can conclude your answers. Okay. So, it is all about giving some constitutional provisions, giving examples. Okay. So, all those things you try to put in your answer. Okay. Come to the next part of the continuation is the emerging trends in federalism. So, what are the various emerging trends in the federalism right now we have in our country? If you see the emerging trends in federalism right now we have. So, if you see the emerging trends include cooperative federalism, which is not a very new thing, which is already an existing concept. But competitive federalism and more of combative federalism today is also visible in our democracy, in our federal political system. So, what basically does it mean by cooperative federalism? Simple, that the units of federalism cooperate with one another. That who are the units of federation? The center and the states. The center and the states, they have to cooperate with one another. So, can cooperation lead to a better result? Of course, the cooperation can lead to a better result. So, that is basically what is called as cooperative federalism. So, there are few examples that I can put it for the cooperative federalism. So, can someone explain me as to how Niti Aayog is an example of cooperative federalism, which has in fact replaced the S12 Planning Commission? At least theoretically, how Niti Aayog is better model than the Planning Commission. States are given a much role in designing their own policies. Earlier, the Planning Commission was following an approach of making a central plan, asking the states to implement. But now it is more of participatory approach. The state has its own representation. No binding directions are given by Niti Aayog, but Niti Aayog is a think tank which can give basically ideas to various states. There are a number of verticals under this Niti Aayog. say education, infrastructure, health, and then science and technology. So, in all these areas, it gives a lot of ideas to the states as to how they can come out with various policy actions. So, definitely it's a collaborative effort between both the center and the states. And in fact, the Niti Aayog Governing Council has representation of not only the Prime Minister but also all the Chief Ministers. So, so this is an example of cooperative federalism. How about GST Council? Can we call that an example of cooperative federalism? What exactly is this GST Council? The GST Council is the apex body today in our country to decide any disputes with regard to GST in our country. It's a constitutional body and which has representation of both center and the states. It will decide the tax rates for various products. And it will also decide as to what are the products and services may be exempted from GST. And any conflicts between the center and the states regarding GST, all those things will be settled down by the GST Council. But how that is an example of cooperative federalism? Voting rights are given to both states as well as the center. In fact, more voting rights are given to whom? To the states. 2/3 weightage to states and 1/3 weightage to the center. But then you need 3/4 of weightage. So, neither the center can unilaterally decide nor the states can unilaterally decide. So, cooperative idea means that both have to come to a consensus on this particular area. So, that is an example of cooperative federalism. Interstate Council, which article provides for interstate council? Article 263 provides for interstate council. So, why I am saying interstate council? So, this is a largely dysfunctional body, but the mechanism is already there under the constitution to provide for cooperation between the center and the states. And the interstate council can also be asked as a separate question in case, if it is asked in the examination. So, that you should know as to why this interstate council is a very influential body, because of the composition that the interstate council provides for. So, who would be part of this interstate council? It will be headed by the Prime Minister himself. It will include the chief ministers of all the states, 6 union cabinet ministers, chief ministers of all the union territories, and the administrators of the union territories which is not having a legislative assembly. So, that means all the top executives in our country, the functional executives of the country, they are all part of this interstate council. Is it not possible that they can resolve the differences through these interstate councils? Say for example, any interstate river water dispute or probably any of the other dispute, say for example, that today there are a lot of border disputes. Now, all these issues can be addressed. Any issues that is concerning the national level, which is affecting the interest of the center as well as the state, is it okay that they can discuss all these things? But today this council is not very functional. They don't meet regularly and it does not happen, the meetings does not happen regularly. But this is an example, this is a mechanism of resolving this dispute between the center and the states. And what about zonal councils? Is it a constitutional body? Is it a statutory body? Yes. So, zonal councils are examples of statutory body established under which act? State Reorganization Act 1956, which has provided for 5 zonal councils. So, every zone will have 4 to 5 states and the Union Home Minister is the chairperson of all these councils. And who would be the vice chairperson? One of the chief ministers in rotation. So, here exactly they can deal with more the issue that I said, that the border disputes between the states. Today there are certain border disputes that is happening in our country. Can you just name some? Maharashtra and Karnataka. In northeastern states, border disputes is already a problem. So, the zonal councils can effectively address such issues. Interstate river water issues can again be taken up by these if they are effective enough. But again, under the constitution, there is a separate mechanism for the interstate river water disputes, but at least the border disputes can be effectively addressed by these things. But again, the zonal councils are also not very effective. So, this is an example of cooperative federalism. Come to the next thing, that is competitive federalism. So, just try to have few examples, that is sufficient enough. Cooperative federalism is more about the cooperation between the center and the states. It is not about cooperation between the state and the states. Because states and states, it cannot create much, you can see that's an element of cooperation, but the idea of cooperative federalism is between center and the states. And competitive federalism is between the state and the states. So, that's why you say that the competition is more a horizontal phenomena, whereas the cooperation is more a vertical phenomena between the center and the states. Competitive federalism. So, do you think that the competitive federalism is also must in our country? It is very, very important that you create competition between the states, because stronger states means a stronger nation. You cannot have a weak link in the chain. Suppose if there is a weak link in the chain, then it is problematic. If there are few states which are not developed, then again you cannot say that the country is a prosperous country. The country is approaching towards development. So, every state has to prosper, and then when every state prospers, the country naturally prospers. That is the idea of what is called as cooperative federalism. So, competitive federalism. That means there should be an element of competition between the center and the states, and in fact, the center should play a very important role in creating competition between the states. Now, how the center plays a very important role? Not every state is equally placed. There is a state which has more resource, there is a state which has advantage in terms of demographic dividend, or the state which has advantage in terms of water resources and natural resources. Certain states does not have it. So, it is not the responsibility of the state to provide more fund to those states so that they can also compete with the other states. So, that is the responsibility of the center to ensure that every state is getting enough resources so they can compete with one another. So, that is basically the idea of competitive federalism. So, few mechanism which is there today through various policies of the center, which is trying to promote competition between the states. Come to this example, 15th Finance Commission, which talks about performance based indicators. One of the terms and references in the 15th Finance Commission is the performance based indicators. That more you perform better in terms of your demographic dividend, more you perform better in terms of health, education index, I will provide you more fund. So, that is not creating competition between the states. So, the idea is that the states have to perform better if you want to have more funds. Okay, that is an example of competitive federalism. Niti Aayog has been following up. One of the ideas of the Niti Aayog is that they come out with aspirational district programs. Do you know what is this aspirational district programs? Some of the districts in most of the states which is backward in nature. So, these backward districts has been identified. And in the backward districts, the central government is giving fund to these states, not only to the state, to various stakeholders, the state government, the district administration, they are all provided fund by the central government, and to improve upon the areas of health, education, infrastructure in these areas. And then the Niti Aayog will continuously monitor as to how the development is happening in these districts. And that is the idea behind this aspirational district program. So, in this way, are you creating competition? So, the government will provide the fund and Niti Aayog will see that which district is doing well and make comparison in terms of their index in various districts. So, this is an example of what is called as the competitive federalism. And today Niti Aayog also produces index on water management by various states, especially groundwater resource has become more scarce. So, how the states are doing in terms of utilizing their groundwater resource index is comparing between all the states. And then multi-dimensional poverty index, health index of every state which has been compared by Niti Aayog. So, these are all examples of what? Creating competition, because every state wanted to perform better in these indexes. World Bank also released one index. Can you remember that apart from Niti Aayog? Ease of doing business index. Have you heard of this? Ease of doing business index among various states is also an example of what? The competitive federalism. Okay, so competition is also a must among the states, but however, in order to ensure competition between various states, the center has an important role. Probably see the aspirational district program is only in some of the states which backward districts. It is not giving the same one to all the states and to all the districts. So, in this way, by giving additional care to the backward area, you are trying to promote and you are empowering that particular state or the district. So, that is the role that the center has to play. Come to the last area, that is combative or confrontational federalism. So, combative or confrontational federalism, so it is a relationship which is basically defined by lack of trust, friction and conflict between the center and the states. So, anything that would lead to lack of trust or it will create friction or mistrust between the center and the states or lack of trust between the center and the states. So, that is an example of combative or confrontational approach or relationship between the center and the states. So, you already seen few examples. GST compensation has created that, unilateral changing of all India services by the center, states withdrawing the general consent to CBI, obstructionist attitude of various governors today is a classic example. Now, say for example, one recent example that you can provide for us, So, for example, the Supreme Court has recently declared that the elected government of Delhi will have control over the services in Delhi, except few areas. But then as a response, what the central government has done? As a response that they have brought in an ordinance, and through that ordinance again they are nullifying this particular judgment. Can you see that is a confrontational approach between the center and the states? Although Delhi is not coming under true federalism, but it is also, in fact, the Supreme Court has recognized that there is a element of federalism, but Delhi has an asymmetric federalism, not like the states, but it has its own element of federalism. Okay, so these are all examples of, can you give other examples for the governor who is creating the obstructionist attitude? Tamil Nadu Governor Mr. R. N. Ravi's action unilaterally passed the order to remove a minister which is not within his domain, but later he has taken back this particular order. And he has left out reading certain portions of the speech during the motion of thanks, sitting on the bills passed by the state legislature of Tamil Nadu, same with Mr. Arif Khan in Kerala. So, all these things are the obstructionist attitudes of the governor, which is definitely not good for the idea of what is called as cooperative federalism. And this can only create the rift between the center and the states, which is not good in our country. Okay. So, this is some examples that you can make. Your examples, I am telling you again with polity paper, only 4 or 5 things that is sufficient enough and make your answer outstanding in comparison to that of the other candidates. You should have a small definition where you can express more, writing less, such kind of definition. You should have certain articles, you should have certain case laws, you should have certain court judgments, case laws, and probably certain theories or certain principles of the Supreme Court and few recommendations which is given by certain committees, which can be used in your conclusion. Mostly try to make your conclusion in a positive manner, in a proactive manner. Okay. So, do not make it a pessimistic approach. Always it should be very positive approach and it should be proactive when you conclude the answers. Okay. So, have a look into this particular question. Once there was a question, how far do you think that cooperation, competition and confrontation have shaped the nature of the federation in India? That means, in other words, can I say that the kind of federation, the kind of relation between the center and the states, which is basically the federation, the kind of relation between the center and the states in our country is shaped by all the 3 things. Do you have examples of cooperation? Do you have examples of confrontation? And do you also have examples of competitive federalism? So, basically, you should explain with few examples in each and every case. But in your conclusion, you should write that it should be more of cooperation and competition rather than what is called as confrontation. So, in order to avoid the confrontation, you can give certain suggestions. And that is why now I am going to talk about some of the reforms that has been suggested by the Punchi Commission, the Sarkaria Commission, the National Commission to review the working of the constitution, and the Rajamannar Committee which was appointed by the state government of Tamil Nadu. So, quickly some of the recommendation. So, shall I proceed further? Okay, so write down certain recommendations which is given by the expert bodies. Not much here and there you can touch, and already for the governor I have given certain recommendations. So, you can use that also, because office of the governor is one of the area where it can create conflict between the center and the states, and the independence of the governor is very, very important. Okay, so Sarkaria Commission and Punchi Commission, which is also called as the first center-state relationship commission and the second center-state relationship commission. So, both have almost given similar set of recommendations. So, probably you, when you write in the examination, you can use the name of Sarkaria Commission or the Punchi Commission. Or you can say that both the commissions have given similar recommendation. When it comes to legislative relationship, both the commissions have said that the residuary powers should be given to the states. Today, residuary powers is with whom? With the center. So, it has to be given to the states. And moreover, the state should be consulted by the parliament while making law on an item in the concurrent list. Now, what is the advantage of the state consultation before making a law on an item in the concurrent list? The confrontation can be avoided in the first place. So, the states does not make a law which is contrary to them, or the states are saying, okay, we need some element of flexibility in those areas when you make the law, so that because we have our own cultural differences or our own differences, so it may not contradict the law which is made by the parliament. So, this consultation can be a better way that you avoid the confrontation which can go to the Supreme Court. Okay. So, this is what especially, so these are the areas where the confrontation is happening with regard to the legislative relationship. And with regard to the executive relationship, if you see the history over a period of time, many times what the center has done is that the center has unilaterally deployed the armed forces in the states. So, for example, now the Manipur, you can see a lot of issues are happening, the internal security issues in Manipur, which is majorly related to the law and order. But had this been happening in any of the opposition ruled states, probably the center would immediately deploy the armed forces. Immediately deploying the armed forces without the consent of the state means it's a clear indication that there's a law and order failure in that particular state, and that's a ground on which the president rule can be imposed. So, the Sarkaria Commission and Punji Commission has made that before you deploy the armed forces, you have to consult with the state, you have to take the state into confidence. Without the confidence of the state, without consultation of the state, so do not unilaterally deploy the armed forces, which can also lead to the misuse of Article 356. And then with regard to the financial relationship, this is the most important concern today the states have. Reduce the cess and surcharge, and also increase in the divisible pool of revenue rather than decrease in the divisible pool of revenue. In fact, this has been pointed out by the 15th Finance Commission also. So, here you can make use of. So, here it is not only by the Sarkaria and the Punji Commission, this is also told by the 15th Finance Commission. And then apart from that, Rajamannar Committee. So, do you know what is this Rajamannar Committee? It is a committee which is established by the government of Tamil Nadu. So, it may not be very important as like the Sarkaria Commission and Punji Commission, but if you have this scope for time and you have more space to write, then you can make use of this recommendation also. So, what the Rajamannar Committee, especially with regard to the Financial Commission, the Rajamannar Committee is completely against the idea of this model of division of powers. In fact, Rajamannar Committee wanted to give more powers to the states because Tamil Nadu government is openly of the idea of what is called as the federal system, where the powers are equally given to the states or more powers are given to the states, as in the case of United States of America. So, more divisible pool of revenue, that is what first they wanted, and more items should come to the states. In fact, they were of the idea that there should be no concurrent list, everything should go to the states, okay, and the residuary power should come to the states. So, all these things were of the idea of the Rajamannar Committee. And the legislative relationship, if you see, the center not to make laws affecting the state's interest, and if any law is made by the center affecting the state's interest, it can happen only after the approval of the interstate council. This is what the Rajamannar Committee has recommended. The National Commission to review the working of the constitution, what they said? That the mandatory consultation with the states while the center is making a law on a concurrent list in order to avoid any confrontation. It is similar to that of the recommendation which is given by the Sarkaria and the Punji Commission. So, you can use it wherever it is required according to the type of question. So, just one point also, it will give you a good way of concluding your answers. So, that is why I have given all those things. Now, moving to the last aspect of our discussion as to what any specific issue that can be asked as an examination. So, till this point of time, we have been seeing the emerging trends, and then we have seen the constitutional design and the issues arising out of the constitutional design. So, if at all a specific question that can be asked, which has already been asked, is again the issue of the tussle that is happening between the elected government of Delhi and the Lieutenant Governor, who is the representative of the Union government. So, let me just give a brief idea about that very quickly. So, let us move to the next topic. So, questions can come from those areas. Okay, before that, what are the principles and doctrines you should make use of in your answer? You should use such words in your answer. Is federal supremacy, that explains, that gives a lot of idea to the examiner as to what kind of understanding that you have. Harmonious construction, if it is required, but federal supremacy, definitely you can use it according to the needs of the question. Doctrine of pith and substance, colorable legislation, SR Bommai case, which has acted as a balancing wheel to prevent the misuse of the executive power by the center, and in fact, in SR Bommai case, federalism has also been declared to be part of basic structure. And then you can also use the word fiscal federalism. The Finance Commission act as a balancing wheel between, in terms of the fiscal federalism between the center and the states. So, such expression you should put it in your answer paper, and that you will put only when you constantly revise these things. So, such expression will make your answer more expressive. You write less, but it still becomes more expressive. No, you don't have to do that. Say, for example, you can merely say that the Constitution of India inherently provides for what is called as federal supremacy. You don't have to explain that. If you have the time, you can explain it. If you don't have the time, you can just leave it. The examiner will understand that. Okay, come to the last part of our discussion. I'll also briefly touch upon after this the interstate river water disputes, very briefly. But this is going to take around 15-20 minutes time. Interstate river water disputes 5 minutes time. So, overall around 20-25 minutes. I'll just wind up the lecture. Okay, if you want, you can just make a note of it. I'll just have a cup of water and then I'll continue. Okay, so this is one issue which is continuously in news. I think around 2014-15, it is continuously there in news. The moment Aam Aadmi Party came to power in Delhi, it has been continuously there in news since that point of time. So, the tussle that is happening today between the elected government and the lieutenant governor who is representing the central government, or to be very specific, who is representing the President of India. Because ultimately the union territories are under the charge of whom? The President. The President is to administer the union territories by virtue of which article? Article 239 of the Constitution. Okay, now let us try to understand briefly as to what is the history of the National Capital Territory of Delhi today, and also how the special status, what was the background on which a special status is given. After the special status is given, what is the conflict that is happening between them, and how that conflict was resolved by the Supreme Court of India in its 2018 judgment. And then subsequently also the dispute continued with regard to who will have control over the services in Delhi, over the bureaucrats in Delhi, and which was settled by the Supreme Court, but the Supreme Court could not completely settle it because there was a split verdict. And then subsequently a constitutional bench, 5 bench of judges of the Supreme Court, has given an unanimous verdict with regard to who will have control over the services. And then as a reaction to that, today the parliament has enacted, not the parliament, the executives, the president has come out with an ordinance. So, all those things we will try to understand. Listen to me and then you can make a note of it. So, just take it in your ears also. And then once you take it into your ears, I will just give time, then you can make a note of it, so that you don't forget it. If you just write it, you will forget it. If you listen and then if you take the notes, you will retain it for a long period of time. At the commencement of the Constitution, if you see that the states in India was classified into Part A, Part B, Part C and Part D states. In Part D, you know that only Andaman and Nicobar Islands was there. Part C states were basically the commissioner provinces. When India became independent, there were few provinces called commissioner provinces. They were provinces, but there was no elected government. There was a commissioner who was appointed, who was ruling that particular area. So, Delhi was a commissioner province. But this commissioner province was given a legislative assembly. This was unique than the other commissioner provinces. It was given a legislative assembly, and for that a law was passed by the provisional parliament. And it was the Government of Part C States Act. So, that has provided a legislative assembly to Delhi. Okay. So, a special status was already there to Delhi. It had a legislative assembly. Not the other commissioner provinces were having that status. And then subsequently what has done, you know that then subsequently there was a reorganization that was done by India, that was done by the parliament. In fact, you know that how Andhra Pradesh was created, and then there was a protest throughout the country. Then they have gone for a linguistic reorganization. First reorganization commission was appointed on the recommendation of the first reorganization commission. A large scale reorganization was done. It was done by the First Reorganization Act 1956. And after the Reorganization Act was passed, Delhi became a normal union territory. So, for the first time, do you know when the word union territory was inserted into the Constitution? Only in 1956 by way of the 7th Constitutional Amendment Act. Before that, the word union territory was not there in the Constitution. 1956, the Reorganization Act was also passed, and the 7th Constitutional Amendment Act also was passed. And thereby they inserted the word union territory. Now, please understand, to reorganize the states in our country, does it require a constitutional amendment? I mean to say, does it require a constitutional amendment by special majority, or by a simple act of parliament you can amend the constitution? But then what was the need for the 7th Constitutional Amendment Act then? When I say 7th Constitutional Amendment Act, this was passed under Article 368 by special majority. And now you are saying that to reorganize, there is no need to amend the constitution by special majority. But in addition to the Reorganization Act 1956, a 7th Constitutional Amendment Act was also passed. Now remember, to make any reorganization, it can be done by a simple act of parliament. It does not require a special majority under Article 368, only to make changes to Schedule 1 and Schedule 4 of the Constitution. If you are going to make changes to any of the other provisions apart from Schedule 1 and Schedule 4, then it requires a constitutional amendment. Now, by the 7th Constitutional Amendment Act, they introduced a separate part for union territories. They inserted the word union territories in number of other provisions outside the Schedule 1 and Schedule 4 of the Constitution. For all these things, it requires a separate Constitutional Amendment Act. So, anyways, that is an extra information. So, when by the State Reorganization Act, Delhi was becoming a normal union territory. But earlier they had a legislative assembly. Now it has become a normal union territory. That means the people of Delhi were deprived of their voting rights. That means the people of Delhi were not having a legislative body to represent themselves. So then the people of Delhi started demanding that they should be given a full-fledged statehood. We deserve to be part of a state. And India being a federal political system, Delhi should have a state. Already it had a legislative assembly. So the people of Delhi started making this demand. But the central government doesn't want Delhi to be a state. The central government, because of its national interest and to have control over Delhi. Because once it becomes a state, it becomes very problematic. Once it becomes a state, then the entire law and order will under the control of whom? State government. Then probably even the Prime Minister who has to move from one place to another place, he has to take permission from Mr. Kejriwal. So it is a big problem because then Kejriwal can show who he is to Mr. Prime Minister. So all these things, the center also knows about that, and to have a better control over the national capital territory, and most of the security institutions, the research institutions, all are there in Delhi, which the center should have control, and that is the model in most of the countries across the world. So the center wanted this to be a union territory. So then the protest was there on the one hand, then the interest of the center was on the other hand. So to look into this particular matter, a committee was appointed, S. Balakrishnan Committee, in 1987. So they recognized both the interest of the people of Delhi and the interest of the central government. And then they said, they came out with a model that we cannot give full-fledged state, but they can give a special model, a separate special status to Delhi. And they recommended the special status, and that was accepted largely. And then that special status was given to the Delhi by a way of a constitutional amendment. So 69th Constitutional Amendment Act was passed in 1991 to implement the recommendation that was given by the Balakrishnan Committee, and thereby they inserted what is called as Article 239AA. So to understand the dispute that is happening between the center, that is the Lieutenant Governor who is representative of the center, and the elected government today in Delhi, for which we will have to understand what Article 239A of the Constitution provides for. Already Article 239 was there. That Article 239 says all the union territories are to be administered by whom? The President. But Delhi has been given a special status under Article 239AA. So we will have to understand as to what kind of changes was brought in by Article 239AA very quickly. So first thing, what Article 239AA, overall it has given a special status to Delhi. How? Article 239AA in fact renamed Delhi as the National Capital Territory of Delhi. So first it has said that it will no longer be called as Union Territory of Delhi. How it will be called? National Capital Territory of Delhi. And this National Capital Territory of Delhi henceforth will have a Lieutenant Governor who will be appointed by the President. And in addition to that, it will also have a legislative assembly of its own who will be elected by the people of that particular state. That is Delhi, National Capital Territory, it will have its own legislative assembly. And then there will also be a council of ministers who will be coming out of this legislative assembly, who will be appointed by the President of India. And on top of that, this legislative assembly will have the law-making powers like that of the other state legislative assemblies in our country. But then the only difference is, the legislative assembly of the National Capital Territory of Delhi will have the law-making power on all the items in the state list, which is there in the 7th schedule of the Constitution, except item number 1, 2 and item number 18. That's a difference. So, because it is not a full-fledged state, but the other states are full-fledged states, so they will not have the law-making power in items which is mentioned in 1, 2 and 18. So, 1, 2 and 18 correspond to public order, police and land. Try to remember this order, public order, police and land. Or you don't write 1, 2 and 18, directly mention public order, police and land. If you are changing the order, if you are not remembering the order, then just write the names. If you are writing this number, then it should also be written in the same order. Public order, police and land. So, except for the public order, police and land, who can make the laws? The Legislative Assembly of Delhi can make the laws. But this is most important. So, with regard to public order, police and land, who can make the laws? Not the central government, the parliament. The parliament can make the laws. The Legislative Assembly of Delhi does not have the power. But it does not deprive the power of the parliament to make laws on any of these areas. So, the parliament can make laws on all the items in the state list in case of Delhi. But the Legislative Assembly of Delhi will also have concurrent powers to make laws on all the items in the state list except what? Except public order, police and land. Okay, so this is the understanding you should have. So, few more provisions quickly, I'll just go ahead and we'll try to understand. So, the conflict started arising from what is called as Article 239AA Clause 4. This is where the conflict has arisen between the legislative, the elected government of Delhi and the Lieutenant Governor of Delhi. So, what is this Article 239AA? So, already said as to what kind of special status it has given. So, what this Article 239AA Clause 4, or if you are not remembering this, you can just mention Article 239AA also. But it will be better that if you can mention Article 239AA Clause 4. So, what this Article 239AA Clause 4 is saying, that in case of differences of opinion between the Lieutenant Governor and the elected government of Delhi on any matter, be it any matter, then the Lieutenant Governor has the power to refer that particular matter to the President and can act according to the direction that is given by the President. Suppose a bill is passed by the state legislature or any executive action is taken and then they are referring that particular matter to the Lieutenant Governor of Delhi. And if the Lieutenant Governor of Delhi is having a differences of opinion with that of the elected government, then what he has to do? He cannot decide on his own. No power is given. The Supreme Court has made it very clear that there is no power which is given to the Lieutenant Governor. You are supposed to transfer that to whom? You are bring it to the notice of the President. And as directed by the President, you can act. So, this is what is the provision under Article 239A4. But what has happened by the successive Lieutenant Governors who are appointed by the centre? Probably they were appointed on the condition that you will have to use these powers, or rather you have to misuse these powers. So, what they have started doing over a period of time, Lieutenant Governor after Lieutenant Governor, whatever is conveyed by the government of Delhi, they had a difference of opinion. And then what they have done, they have referred to the President. And then the President has directed contrary to what has been decided by the Delhi government. Then ultimately, then there is no meaning for the Delhi government. So, that is why this matter has gone to the Supreme Court. And now the Supreme Court has to decide as to what is the scope of power of this elected government. Does this matter, any matter will include every matter? Because that is what exactly the Lieutenant Governor was doing. He was referring on every matter to the President. And they were acting according, and the President acted on the aid and advice of the Union Council of Ministers. So, the Supreme Court has to determine as to what is the meaning of this particular word, any matter. Does the any matter include every matter, or any matter means only those matter where there are substantial differences of opinion. It is not that every petty matter will be referred to the President. So, this has to be decided by the Supreme Court in this particular case. It was a good judgment in the opinion of the legal experts, but it had some ambiguities as well. I will discuss about the ambiguities a little later. So, after I think 3-4 years, the judgment after the matter started, I think 2014 or 13 the matter started, and then in 2018 the Supreme Court gave the judgment. The Supreme Court has made one thing very clear, that we will have to understand: Delhi is not a full-fledged state and the Lieutenant Governor is not a full-fledged governor. So, he cannot act like a governor, and then the elected government of Delhi cannot act like a full-fledged state also. So, both have limitations under the constitution, because this is only a special status that is given to you. You cannot expect you to behave like a state government of other states. And then the Lieutenant Governor is just a nominee of the whom? Nominee of the President. You are just an administrator who is appointed on behalf of the President. So, you cannot behave like a full-fledged governor. So, both the things are not true. So, you will have to understand your own limitations. And one thing that the Supreme Court has made it very clear, that there is no independent decision-making authority to the Lieutenant Governor. So, you cannot do anything on your own. You will have to just refer it to the President. And similarly, it has made it very clear, any matter under Article 239AA Clause 4, because in case of differences of opinion on any matter, he can refer it to whom? he can refer to the president. So, this any matter should not be misused or any matter should not be misunderstood. So, this any matter under Article 213A doesn't amount to every matter. Mr. Lieutenant Governor, you have misunderstood this particular provision that will refer each and every matter to the president. No, this should not be the case. It should be a matter of substantial policy matter. Suppose let us assume that the government has decided to appoint a particular person as making some appointment, or the government is coming out with some policy decisions to a welfare measure for the people of Delhi. You cannot refer to the President of India. It should be a substantial policy matter. But the biggest lacuna of this, what amounts to substantial policy matter has not been defined by the court, and it cannot be defined also. And that is why the court has said that while exercising this particular power, the Lieutenant Governor has to exercise what is called as constitutional objectivity. So, your idea should not that you have to create problem to the state. The idea is possibly that this policy can have some kind of impact upon the people, or this policy may not be good to the people, and hence you exercise your constitutional objectivity in referring this particular matter to the president. And your intention should not be to obstruct the state government. That should not be the idea. So, when there is constitutional objectivity, you take into account the larger interest of the people, and there is no interest to create problem to the states. And in that particular case, there you are exercising what is called as constitutional objectivity. And further, the court has said that because Delhi is having a special status, and what is a special status that is given to Delhi? That the Legislative Assembly can make laws on all the items except public order, police and land. So, the court has made it very clear that there is no need to take the concurrence of the governor in every matter, and the executive power is coterminous with that of the legislative power. That means, wherever the legislature is able to make the laws on all those areas, the elected government can also have the executive powers, and it is not that you have to give the permission in each and every case. But despite that, if you have a substantial difference of opinion, you can refer it to whom? To the president. But while referring the matter to the president, you will have to exercise what? You will have to ensure constitutional objectivity. You should not function with an intention of creating obstruction to the elected government. That should not be the way you should function, Mr. Governor. So, this issue has been sorted out as to what are the areas on which the executive power of the Delhi government exercises. So, the executive power will be coterminous with that of their legislative power. But still, can the governor refer the matter to the president? Yes, but with constitutional objectivity. So, what amounts to constitutional objectivity has not been seen, but what the court may apply in the future if the governor is creating some problem, whether the governor has exercised constitutional objectivity, whether the governor is referring this with an intention of creating obstruction to the elected government. So, again it may lead rise to scope for some kind of disputes in the future. But if the governor is a very neutral person, if the governor has no any vested interest, then it can create some element of clarity as to how it has to function. And the matter was not over there. And at that point of time, what is the biggest criticism is that the court failed to explain as to what is a substantial policy matter. And the court cannot give examples to this also. That is why the court said you will have to exercise what? You will have to exercise constitutional objectivity in doing that. You should not act as an obstructionist, but rather you will have to exercise constitutional objectivity. And when that matter was resolved, there was another matter that was pending in front of the Supreme Court is that who have control over the services in Delhi. That means who can appoint the bureaucrats in Delhi. And that matter was sub judice. And then I think in 2021 a judgment was given, but that was a split verdict. That one of the judge, a two-judge bench was looking into this particular matter. One judge has said that who will have the control over the services is that the Delhi government will have control over the services. The other judge said no, ultimately who is in charge of all those things? The president. And hence it is the central government who will have control over the services. And because of the split verdict, the Supreme Court of India has referred this particular matter to a larger bench, which has been recently, I think in May 2023, the judgment was delivered by the Supreme Court. So, do you know what the Supreme Court has delivered? That the Delhi government will have control over the services on all those areas where the Legislative Assembly of Delhi will have the power to make laws. That means, what are the areas on which the Legislative Assembly of Delhi will have the power to make laws? Except public order, police and land. So, in all those areas, the executive power is coterminous. That means in all those areas that the Delhi government will have the power to appoint the bureaucrats, and the Delhi government will have control over their transfers, their action over indisciplinary activities. Now, number of instances that the bureaucrats were not even attending the calls of the ministers. Think of the position that the bureaucrats are not attending the calls of the ministers. And do you think that the government can enforce accountability over the ministers? Sorry, the government can enforce accountability over the bureaucrats. So, the Supreme Court has said it very clear in the 5-judge constitutional bench, and in fact, the Supreme Court has brought out a triple test of accountability. And what is a triple test of accountability? That first of all, the bureaucrats have to be accountable to the ministers. That is very important. And the ministers have to be in turn accountable to the, so I think 3 levels of accountability. One is the bureaucrats accountable to the people, and the bureaucrats accountable to the ministers accountable to the legislative assembly, and then the assembly accountable to the people of this particular Delhi. So that is a triple test, and in order to ensure that the ministers, the government in Delhi should have control over whom? Should have control over the bureaucrats, except in those areas of public order, police and land, because that is not within your legislative competence, and hence your executive competence to appoint the bureaucrats will not extend to those areas. That's a decision that was given by the Supreme Court in May 2023. In order to suppress, in order to nullify that particular order, the Supreme Court, the central government has come out with an ordinance. And what is that particular ordinance? And that ordinance is in fact has created an authority which is called as, do you know what is that authority? National Capital Civil Services, NCC, Civil Services Authority, a National Capital Civil Services, NCC, I think, Civil Services Authority. Now, this National Capital Civil Services Authority was created by an ordinance route. And what is this ordinance saying? Henceforth, it is the National Capital Civil Services Authority will have the control over the appointment of bureaucrats in Delhi. And this National Capital Civil Services Authority in Delhi will have the Chief Minister as the head of this particular authority, and it will have the Chief Secretary and the Principal Home Secretary. Although the Delhi Chief Minister is the head, he will not have the complete powers. The other 2 people can veto his decision. And in case of any differences of opinion among them, the final decision will be taken up by the Lieutenant Governor. So, in this way, they are trying to take away the powers of the Chief Minister. But what is the rationality with which this judgment was given by the Supreme Court? The Supreme Court has given the judgment on services and the other areas also, respecting the federalism on the one hand, because the Supreme Court of India in this particular case on services, it was explicitly recognized by the Chief Justice of India, D.Y. Chandrachud, that yes, Delhi forms a federal structure. But here the federalism is an asymmetric federalism. It is not like the other states, it's a different level of federalism, but definitely there is federalism. And in order to respect the federalism and the democratic principles, what is about democracy? Democracy is all about a government elected by the people, and that particular government should be accountable to the people. And that government to be accountable to the people, it has to exercise the powers. So, if you are not giving the services to this particular government, then you are not respecting democracy, and you have to respect the democratic principles and the principle of federalism, and therefore, the services should be in the hands of whom? It should be in the hands of the elected government. It should be coterminous with that of their legislative powers. But that this ordinance is not respecting those principles. Can the parliament nullify a Supreme Court judgment? Now, the question is, can they nullify a Supreme Court judgment? Of course, the parliament can do that. There is nothing wrong in that. It is a power of the parliament to do that. But what that ordinance or what that law that is made by the parliament or the ordinance issued by the president, it has to take into account as to what is the reason behind that particular judgment. If they are nullifying a particular Supreme Court judgment, then the idea is that the judgment was given for some reason, and they have to take into account those reasons, and without violating those reasons, they can make a law, and to that they can nullify the judgments. But now, do you think that this National Capital Civil Service Authority is nullifying the ideas of democratic principles? Is it taking care of the idea of democratic principles and the idea of federalism? Again, it is violating. and but they have the power to do that and they are doing it. So again, this ordinance is subject to judicial review. Already the Delhi government has challenged this ordinance as well, and very likely it may be struck down because it is not taking care of the previous judgment. So that is the idea you should have, and in fact in the DC Wadhwa case, it has been clearly said that if an ordinance was brought in with a mala-fide intention means any ordinance which is brought to meet a political need or to meet or to achieve any political interest is a mere intention behind the ordinance, then that ordinance is a ordinance which was passed with a mala-fide intention. So again, the critics say that it is very much liable to be struck down on the directions of the DC Wadhwa case, this particular ordinance. Okay. So all those things you can make it if at all a question comes. And in the meantime, as a continuity, the Delhi government has also, the parliament has also brought with one more law, which was passed in 2021. You might be aware of this particular law also. The Government of National Capital Territory of Amendment Act 2021. And in fact, it has also made significant changes. It has made few changes in the earlier law, the 1991 law. Here they said that the Delhi government would mean the lieutenant governor, not the elected government. And then the legislative assembly, they have made changes with regard to the powers of the legislative assembly as well. So what are the changes that they have made? The government of Delhi would mean the lieutenant governor, and his concurrence must be required in all the decisions. So this law is also under challenge. This is also sub judice. But what is the change that they have made? That the lieutenant governor would be considered to be the government and his concurrence is required in all the decisions. And most importantly, they have not only touched upon the powers of the elected government, they are also trying to infringe the powers of the Legislative Assembly of Delhi under this particular act. So they also deprive the rule-making power of the Legislative Assembly and prevent the Legislative Assembly of Delhi from setting up committees to inquire into the administrative decisions. Now, please understand, any legislative assembly can set up the committees. So, all the states legislative assembly have their own committees and the committees can inquire into the administrative actions. So, thereby there is an accountability of the executives towards the legislature. But here this act is saying that the Delhi Legislative Assembly cannot set up the committees to look into the executive actions. That means, are you depriving the power of a legislative body, which is the very essence of the parliamentary democracy? So that is also part of this particular law. And the act may also have retrospective effect on the rules made by the Legislative Assembly of Delhi. This is very important. That means this act says that before the act, if any committee was set up by the Legislative Assembly of Delhi and if they come out with certain recommendations, all those things can also be declared to be null because the act will also have retrospective effect. So that means completely they are trying to take away the power of the elected government as well as the elected legislative body, which means you are completely making it a body despite the fact that there is an elected government and an elected legislative body, but a body with no powers. And the real powers will hold in the hands of whom? The lieutenant governor. So this act is again sub judice. So this is again criticized that it clearly goes against the mandate of Article 239. It clearly goes against the Supreme Court judgment of 2018. And it is also against the spirit of what? The federalism, which has been declared to be part of basic structure. So this is a criticism. Again, this is subject to judicial, it is sub judice. So what are the things that you should remember when it comes to Delhi? You should remember about Article 239AA. What is a controversy, especially the power of the governor under Article 239AA clause 4 and the Supreme Court judgment in 2018. What is the matter related to services and what the Supreme Court said and what is the reason as to why the Supreme Court gave that particular judgment with regard to services. The triple test is something that you can write as a part of your answer. And then the ordinance and what is the controversy surrounding the ordinance. And DC Wadhwa case, you can quote it here in case if there is a need. And then the Amendment Act which was brought in 2021, how it is basically and what is the provision and basically what is the criticism. So try to remember all those things. So this, the entire issue that is surrounding Delhi is covered. Okay, so basically they can ask you questions directly from these areas. And these are all some of the key words that you can use it as a part of any answer for that matter comes from federalism. In addition to the doctrines that I have already said. Okay, so when you are taking photographs, make sure that I am not there in the photograph. Okay. Or you just tell me that you are going to take the photograph, I will just move aside and then you can take use of the photograph. Alright, henceforth take due caution when you are doing that. Okay. So the key words that you can use is cooperative, combative, collaborative federalism, top-down approach, constitutional design, fiscal federalism, federal bridging institutions. What are federal bridging institutions? Zonal councils, Niti Aayog, interstate councils. So these are all the federal bridging institutions. Lack of consultative mechanism, strong center at the same time, autonomy to states. So try to make use of all these words wherever it is relevant, along with the various principles that I have told. Okay, now we'll move to the last part, is that I'll briefly touch upon the interstate councils. Previous slide. So let it be done first and then I'll move to the previous slide. So if you are done with this, all of you please let me know. Just 5 more minutes and then I'll complete the class with regard to interstate council. If you are done, let me know. So federalism, I am very sure even if you remember these things, it is more than sufficient for your examination. Apart from this, you cannot remember more information also. So what probably you can do is, probably I might have missed 1 or 2 current affairs, a specific incident. If you want, you can focus on that. But again, do not go and waste time in again reading for federalism. Try to revise these things. Okay. If you can recollect these information, you cannot write all the information in the examination, whatever has been discussed in the class. But one student might get better marks than the other because how effectively he is using these information at the relevant places is what matters. You cannot just go and write whatever you know, but may not be relevant to the question. You will have to use the relevant information to the question. Okay, so just have a look into this particular question. Whether the Supreme Court judgment, so this was asked in 2018 or 19, whether the Supreme Court judgment in July 2018 can settle the political tussle between the Lieutenant Governor and the elected government of Delhi. Examine means you will have to make a deeper analysis of this. So how many of you think yes, it can address? It can address only if the governor can exercise constitutional objectivity. If the governor doesn't exercise constitutional objectivity, then it is still a problem and he can still act as an obstructionist. So the idea is that the governor exercises constitutional objectivity, then it can address the issues. So probably in this question, you'll have to say as to what is the issue. You can briefly give an introduction as to what was the position of Delhi and how the historical background behind the 69th Constitutional Amendment Act, the special status that is given to the Delhi. You can briefly explain about Article 239. And what is the issue? Article 239, AA class 4 is the issue. And then what is the judgment that is given by the Supreme Court? And then you can make your assessment. Okay. So very briefly, all these things, if you put, you can get 6 to 7 marks if it is a 10 mark. 60% mark is assured if you can write all those things with the expression that I have told. Okay. So come to the last topic, that is the Interstate River Water Disputes Act. And what is the relevant constitutional provisions for this? Article 262 of the Constitution. Article 262 of the Constitution and the legal provision that we have right now is the Interstate River Water Disputes Act 1956. Now, why I have taken up this for example? A law to amend this Interstate River Water Disputes Act is still pending in the Parliament. Interstate River Water Disputes Amendment Bill 2019 passed by Lok Sabha, still pending in the Rajya Sabha. And it is trying to make some of the structural changes and the procedural changes in the previous version of the law, which they think that it can improve upon the mechanism as to how the interstate river water disputes can be addressed in our country. Now, under Article 262 of the Constitution, the Constituent Assembly was very clear that in a country like India, interstate river water disputes are likely to arise. And they said that this interstate river water dispute, whenever it arises, who is going to take care of this particular dispute? Not the Supreme Court. Although it is a federal dispute, it will not go to the Supreme Court, but it shall be taken up only by such an authority as may be determined by an act of Parliament. This is what Article 262 says. According to the power that is given to the Parliament under Article 262, the law that was made is what? Interstate River Water Disputes Act. Now, can someone tell me what are the inherent flaws in the interstate river water disputes today in our country? Delays, very good. One is delay for 2 reasons. Now, one, you think that today that there is a provision for only ad hoc tribunals. You know what is this ad hoc tribunal? That means there is no permanent tribunals, and whenever the case arises, then the government will appoint a bench for that. Now, the biggest problem is establishing and appointing itself will take a lot of time. First, you will have to find suitable person, you will have to recruit them, then you will have to appoint them. Then it itself will take 2-3 years. for the government to do that. It has to issue notification, and then on top of that, then they have to work on this particular issue. So automatically it has led to a lot of delays. So for example, the Kaveri River Water Tribunal has taken more than 17 years for them to give the judgment. And the law says it has to be done within 5 years, maximum 5 years. But then the judges, if they deliver the judgment within 5 years, then they'll not have any benefit of it. More the time that they prolong, more salary for them, more benefit for them. So they also sometimes prolong it. So delays is one of the biggest issue. Is there any of the other inherent problems of the tribunals, interstate river water tribunals today? Lack of expertise is an issue. Say for example, today mostly only the people with the legal knowledge, the retired judges are part of the tribunals. But to solve the interstate river water tribunals, one of the very objective why you should not go to the court is you need to have someone who is having a technical expertise. But today not much people are having the technical expertise. So for them to understand these technical data, what is the volume of water and how the water to be shared, what is the need. For the judges with legal knowledge, they cannot understand that. It also takes a long time. So the new bill is trying to address all these issues. Any of the other issues? So conflict between the state that is why the issue arises in the first place. Other issues in terms of how the present mechanism has failed to give quick solution to this dispute. I mean, I am trying to ask what is the problem with the present version of the law. There is no centralized data available immediately to them. Once the dispute arises, then they have to work on the data. So under the present law, there is a mechanism for having data. But who has to maintain that particular data? The central government has to maintain the data. But the central government is not maintaining the data. So the new version of the bill, you will understand that the bill says, the interstate river water dispute bill says that there should be an external agency who should be given this particular job of maintaining this data. So probably you have to outsource this particular function and who will provide the data as and when there is a conflict. So in this way, they try to feel that there can be better efficiency rather than the government doing it. I'll just discuss about the provisions also. What are the other things? One of the biggest issue is the politicization of the interstate river water disputes. Do you know today under the Interstate River Water Disputes Act, that once a judgment is given by the tribunal, that judgment cannot be implemented unless and until the central government gazette notify that particular judgment. But after the tribunal gives the award, for certain political reason, the central government does not notify these awards. So probably that, say for example, if there is a dispute between Tamil Nadu and Karnataka, suppose let us assume that there is a BJP government in Karnataka and then the Tamil Nadu government is against the BJP government, let us assume, for example. Then the central government may not even notify this award, and unless and until they notify this particular award, there is no need to implement this particular award. So despite the award is given, the central government has to notify. But the new bill now says that there is no need for this gazette notification. Once the award is given, it has to be implemented. So in this way, they are trying to bring certain issues which is already there, and they are trying to address that in the new version of the bill. Okay. So what are the present structural or the process inadequacies in the present system? When I talk of the present system, it is in the Interstate River Water Disputes Act 1956. First thing is there is a pre-negotiation process. So in the present version of the law also there is a pre-negotiation process. What is this pre-negotiation process? Pre-negotiation process means whenever two states have any dispute. So first of all, the matter will be referred to the central government. They will take it to the central government, and the central government before appointing the tribunal, they will try to resolve the disputes. So the central government will appoint a committee to resolve this particular dispute. But today in the present version of the law, the pre-negotiation process does not have any representation from the states. So who will try to resolve the dispute? The central government itself. But under the new version of the law, if you come to the next page, the bill in 2019 bill, if it becomes a law, then there is a need for what is called as a dispute resolution committee. So this dispute resolution committee is a pre-negotiation process. So before the tribunal is appointed, they will try to resolve this particular dispute through negotiation between the states. And this dispute resolution committee is the one who has to engage in this pre-negotiation process. But here, there is representation from both the states as well as the center. So the center will not unilaterally decide this. There will be representation from the state which is having the issue, and then the central representative will also be there. They will all combinedly engage in the negotiation. So negotiation should involve the affected party, isn't it? Earlier, the affected party was not part of the negotiation process. Then how can you expect the negotiation to be successful? So here, now they are recognizing that. Okay. So don't write everything. Let me just compare the things. And then the second thing is, earlier there is a need for an ad hoc tribunal, which take a long time for them to appoint. But now the new bill is saying that we will not have ad hoc tribunals, we will have permanent bench. We will have one single permanent tribunal, that the Interstate River Water Tribunal will be a permanent tribunal with multiple benches. So, what is the advantage of having a permanent tribunal? That once there is a dispute, immediately the matters can be referred. So, ultimately it can bring down the time. Okay, so that I will share. And then the next issue is the lack of expertise assistance. Now, in the new version of the bill, it is made sure that the people with the technical knowledge is also part of every bench. In fact, it is mandatory people from the Central Engineering Water Services should be part of the benches when they decide the cases. Okay. So, they are also trying to bring the expertise, address the expertise issues. And the politicization, how it can be politicized, need to publish the award in the official gazette. Now, there is no need for that. And then earlier, there is a need to maintain a data bank on the various water requirements, but then that data bank data on water is to be maintained by the government itself. So, because the government has failed to do this, now this is to be maintained by an external authority under the new law. Okay. So, these are all the changes in the structural and the process, which if passed, it could make the system more effective. And earlier the time limit was 5 years, now that has been reduced to 3 years within which they have to give the award. Okay. So, just make the changes that has happened in the, but this is still a bill, only when the bill becomes an act, you can bring in the changes. So, in case if there is a question on interstate river water disputes, what are the problems in the present mechanism and how it can be addressed? Problems in the present version is on the Interstate River Water Disputes Act and how it can be addressed. So, most of the provisions are already part of the Interstate River Water Disputes Amendment Bill 2019. Okay, so there may be few other topics which is part of the current affairs, but I do not see anything asking as a separate question. Yes, one issue is again that CBI which has been misused, the allegation, but CBI question is already asked. So, probably I assume that you know about the CBI in case a question comes, so I did not touch on that. But otherwise, most of the things I have already covered. If you revise these things properly, you will have enough content to write any question that can come from the federalism. And one more thing, that you just work on the topic of what is called as asymmetric federalism. In fact, Delhi is an example of asymmetric federalism. Jammu and Kashmir earlier was an example of asymmetric federalism. So, if you think that Jammu and Kashmir has now become a union territory, but yes, still Article 371F is there, which is again an example of asymmetric federalism. Okay, so just work on this topic of asymmetric federalism. So, nothing much, that different states exercising different powers. Not every state is having the same power under the, not all the states are having same power under the constitution. That is the idea of what is called as asymmetric federalism. So, almost we are done with the topic of federalism. Yes, because again they are having some union legislature, they have a legislature of their own. But although they are not having the great powers, but yes, we will have to see as to what are the provisions under the law, and because the legislative assembly is not even established. So, it is not yet seen as to how they are practically function and all those things. But yes, because they have a unique model, so they can also be an example of asymmetric federalism. But not as it used to be as a separate state, it was having an entirely different provision. That is not there. Any questions? So, if you are not having the questions, we will wind up the class. So, tomorrow I will take up the topic of local bodies, and along with that I will touch upon certain basics of the comparison of constitution across the world. So, I will try to cover both these topics. Okay. So, the next class also you can definitely expect one question from what we discuss, and then after that we will touch upon the very important topic, although it will not take much of your time, but every year 1 or 2 questions definitely come from that particular area: constitutional bodies, statutory bodies, regulatory bodies, quasi-judicial bodies. So, 2 questions you can expect from that particular topic. So, I will touch upon that on Wednesday, and on Thursday I will touch upon the Election Commission of India, then along with that the electoral reforms, the Representation of People Act and all those things. So, there also you can expect 1 question. Okay. And the next week then I will take up the governance area, which I will cover it up in 3 classes. So, all that we expect is from our classes, minimum we should be comfortably able to answer 12 questions or at least 10 questions from these classes. Okay. So, we will take a break now. So, when we can start our test? 5:30. Alright, we will again meet for the test at 5:30. Okay. Thank you.
StudyIQ IAS. अब तैयारी हुई अफोर्डेबल।